Good morning, Council. This is State of Wisconsin versus Brendan Dassey, 88 CF, or excuse me, 0688 CF. Appearances, please.
The state of Wisconsin appears by Calumet County District Attorney Ken Kratz, Assistant Attorney General Tom Fallon, Assistant District Attorney Norm Glen, appearing as special prosecutors. Attorney Mark Fremgen with Attorney Ray Edelstein appears. Brendan Dassey appears in person.
All right. First to the prosecution. Any motions before we proceed to the jury?
Yes, Judge, we have moved the court uh, for an order amending the information, amending count 3 to second degree sexual assault as a party to the crime. Section 971.29 allows the court to amend an information to conform to the proof where the amendment is not prejudicial to the defendant. We alerted the court and counsel as to the intent to do so, given the state of the record. Uh, State believes that second degree sexual assault more accurately and appropriately reflects the individual behavior of this defendant, Brendan Dassey. And we have provided the court with the original amended information. Copies have been provided to Mr. Fremgen.
Mr. Fremgen, do you have any objection to the proposed amendment?
To the amendment, no.
Court is going to grant the amendment. Any further motions from the state?
Not from the state, Judge.
The defendant?
Judge, we would renew our motion now that all the evidence has been presented and both parties have had, or the states had an opportunity to do rebuttal. But I would move again, as previously. We move this court following the close of the state's case in chief based on essentially moving to dismiss count 3, whether it be now the amended count 3. Again, rather than belabor the argument before, essentially, I would point out to the court the Supreme Court case of 1978, State versus Verhasselt, which I don't think that law has changed since then. In fact, the court had mentioned State versus Bannister case, 2006 case, and I was able to review that. It appears to basically reflect the same state of the law. But essentially, the state of the law is that one may not be convicted solely upon their uncorroborated confession. In the Verhasselt case, the quote is basically quoting Holt, which is the more seminal case from 1962, but essentially indicates as to the need for corroborating evidence. All the elements of the crime do not have to be proved independently and of an accused's confession. It's enough that there be some corroboration. Our position is that there has been no independent corroboration of any element of count 3, and for that reason, we'd ask the court to dismiss.
Mr. Kratz.
Your Honor, I'll be handling this portion of this motion.
Mr. Gann.
Thank you. Your Honor, I have also read State v. Bannister at 2006 decision, and upon reading Bannister, there are so many significant differences between this case and the Bannister case. The Bannister case basically stated that there was absolutely no real trial testimony elaborating on almost any fact of the confession. No details fleshing out anything surrounding the confession. They even noted that there wasn't any testimony about what room a transaction took place in, or how a visit was set up for that drug transaction. When you look at this case from the very beginning, we have stipulated facts of why Teresa Halbach was at the Avery salvage yard. Her purpose for being there for Auto Trader magazine. We have testimony from Bobby Dassey stating that the last time he saw her, she was walking towards the Avery trailer. And in the Avery trailer was the bedroom where the sexual assault took place. So she is at the scene of where the sexual assault took place. Mr. Dassey spoke about the hand irons and leg irons that she was shackled to that bed, hand irons and leg irons that have been introduced in this trial as exhibits. During this questioning and his confession, he spoke about seeing and observing the unclothed body of Teresa Halbach. There's no mention of tattoo or scars or birthmarks or anything unusual. This, I think, goes to the surrounding facts and circumstances. I think also noteworthy about the location of this assault, the bedroom, was that Brenda Dassey spoke of the location of the bed, and I note Detective Wiegert stated how they were somewhat perplexed when he gave the location of the bed, and then they came to find out that the bed had been changed, that the furniture had been rearranged. And that, I think, is a very significant fact about the location of the sexual assault. And just the change of furniture, I think is consistent with all the inferences one can draw from the case. Something very horrific took place in that room. And I think it goes to the inference that cleaning was done. Bleach was found, the Bissell, the vacuum cleaner, and Brendan Dassey spoke of cleaning up that took place. And I think that seeing the furniture moved is a reasonable inference that supports that. Also, I think that just the lack of physical evidence and forensic evidence is consistent with the facts that have been derived in this case. And from the statements of Brendan Dassey, they burned the body of Teresa Halbach. We had testimony from Katie Halbach describing the jeans that she believed her sister was wearing, and the rivets were found in the fire, and the zipper, the Daisy Fuentes rivets. And we also have outside testimony from Mr. Tadic in a stipulation that he saw a huge fire in the burn pit of Stephen Avery on the night of the October 31. Some testimony from Blaine Dassey. I think also the court could consider that the victim knew her assailant. She knew who was assaulting her and sexually assaulting her. And Brendan Dassey spoke about the conversations he had with Stephen about then killing her. And this is not a stranger sexual assault. This is one that the victim knew her assailants. And really, the only course, unfortunately, that I think they decided to take was to kill the person. The only person who could identify them. And probably most noteworthy in this case is the Bannister decision. The court noted that, furthermore, they're not referring to Bannister's confession did not yield any unusual information or circumstances that would not be widely known. And I think that is probably the key sentence in that decision that applies to this case, especially when, after the confession of Brendan Dassey, he spoke of her being killed and shot in the garage, and in the garage is found a bullet. The bullet which has the DNA of Teresa Halbach on it. And that bullet, which was matched to the very gun to the exclusion of all other guns, which was found in the bedroom of where the sexual assault took place. So Brendan Dassey was in that bedroom. We knew where the gun. He knew where the gun was. He told the police where it was, and sure enough, doesn't that match the bullet that was found in the garage? I think I could go on. There are other distinguishing features between our situation and the Bannister case, but I certainly believe we have gone far beyond sufficient information from a reasonable inference of all the evidence, the totality of all the testimony that their motion we did not provide independent corroboration is without merit. Thank you, Your Honor.
Any response, Mr. Fremgen?
Briefly, Judge. Much of what Mr. Gahn points out as far as corroborating detail certainly corroborates the first-degree intentional homicide and mutilating the corpse. The quotation from Verhasselt, which quotes Holt and Triplett, and all the other cases that have come down over the years dealing with this issue, says the elements of the crime. None of the corroborating details pointed out by the state have anything connected whatsoever to do with count 3. Even many of the items or the comments by the state in regards to corroborating details are not so corroborating. The bedroom drawing is not entirely accurate. The tattoo comment in the video, he actually, when confronted by Agent Fassbender, when he says, "Do you disagree with me that there was no tattoo?" he says, "No." Disagree with me that there is a tattoo. He says, "No, I just don't know where it is." As to the handcuffs and leg irons, the state brought handcuffs and leg irons from his own house. Nothing that points to its use in the crime or the alleged allegations, but they were addressed as well. And once again, the issue of the cleanup. On one hand, the state says there was such a meticulous job done to clean up the bedroom, yet Stephen Avery's sloppy enough to leave his blood all over the RAV4. It just seems to be somewhat inconsistent. So we would again stand upon the fact that there is no corroborating detail of the elements of this crime.
All right, I think Wisconsin law is clear. A confession must be corroborated by, and this is quote from Holt, which counsel has cited as significant fact. Holt is at 17 Wisconsin 2D. This is at page 480. Here in this case, we have 3 counts, charge and acts, which occurred contemporaneously. The court believes that the confession given by this defendant is corroborated by a number of significant facts: the bullet fragments, the pieces of bone, the rake, and the shovel, to name just a few. This is sufficient corroboration for the confession as a whole, and that whole includes sexual assault. The reason underlying the necessity of corroboration is, as was said in State vs. Hogg at 257 Wisconsin 2D 579, specifically at page 592, is to quote, produce confidence in the truthfulness of the confession, end quote. This confession is not limited to only the sexual assault. Therefore, significant facts tended to support any part of the confession or tend to support all of that confession. Moreover, even if I were to view the sexual assault count in isolation, I would say, as I already have, that there exists significant facts which corroborated the handcuffs, the leg irons, as Mr. Gahn pointed out, the location of the bed as shown in the drawing, which was introduced here as an exhibit, a drawing of Brendan Dassey. Therefore, I'm going to do as I did before. I'm going to respectfully deny your motion. Now, we have had a chamber jury conference. You gentlemen have had an opportunity to review the proposed jury instructions. First to the prosecution. Any changes, any motions?
No, Judge. We believe that the instructions and the court is correct. We've had an informal jury instruction conference where most, if not all, of these instructions were discussed. We have now reviewed the proposed instruction. We have no objection to the instructions as presented, nor as to the verdict forms as included and set forth within these instructions.
I would just note, I believe that the amended instruction 525, to make it conform to one that was given in the Avery case, I didn't have the opportunity to tell you that before then, but this amendment doesn't do anything substantially to it. Now, to the defense.
Your Honor, as to the packet most recently received, we concur with those that have been made available. I would, for the record, ask the court to enter its ruling on the record regarding the defense instructions specifically requesting that an instruction be provided regarding corroboration.
The defense had customized construct an instruction that, in effect, would have told the jury that before they could find a confession to be a valid confession, it had to be corroborated by I'm going to call it a significant fact, had to be corroborated by something in the record. The court suggested in the informal conference that while it had reviewed that instruction, it was going to deny the defense motion to employ it as a part of the jury instructions. I will now do so formally. I'll deny it on the record. I believe that instruction on the confession is sufficiently detailed in the course of the instruction that's going to be used as part of the particular jury instruction. I've forgotten whether it's 180.
I believe it's 180.
All right, and I think that, it is. Instruction number 180 deals with confessions and admissions, and I think that is appropriate instruction. I do not believe that going what in effect is a legal argument as part of the instruction as requested by the defense is appropriate under the circumstances. Therefore, I'll respectfully deny your motion. Now, what I'd like to do is to make 15 copies of this set of instructions. I'd like the jury to have them as I read them to them, and probably it's going to take another 10 minutes to do that, so I'm going to recess for that period of time. Be seated. Morning, ladies and gentlemen. In a moment, I'm going to be reading you the instructions, the jury instructions. As you can see, the clerk is handing copies of those instructions out. You can see how well I read, I suppose, by trying to follow along with me. You certainly can and are urged to follow along. However, once closing argument has begun by counsel, I ask that you put those down and pay attention to what the lawyers have to say in the closing argument. Additionally, just so you know, at the end of closing argument, before you retire for deliberation, the clerk will have a little drum up here, and we're going to draw 3 names, the names of 3 jurors out of that drum. The first 2 will be discharged as jurors, and the third will be sequestered for the remaining part of the deliberations. All right. With that said, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in this case which have been properly proven by the evidence. Consider only the evidence received during the trial and the laws given to you by the instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has any impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely on your view of the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of that law only. One defendant, 3 counts. The first count of the amended information in this case charges Brendan Dassey on October 31st, 2005 as a party to a crime, did cause the death of Teresa M. Hallback with the intent to kill that person contrary to the sections 940.01, 1A, 939.50, 3A, and 939.05 of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The second count of the amended information charges that Brendan Dassey on October 31st, 2005 as a party to the crime did mutilate, disfigure, or dismember a corpse with the intent to conceal a crime, contrary to sections 940.111, 939.503F, and 939.05 of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The third count of the amendment information charges that Brendan Dassey on October 31st, 2005 as a party to a crime by threat or use of force or violence did have sexual intercourse with Teresa Hallback without the consent of that person contrary to sections 940.225 2A, 939.50 3C, and 939.05 of the Wisconsin statute. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, first-degree reckless homicide, party to a crime, aiding and abetting, defendant either directly committed or intentionally aided the crime charged. Section 93905 of the Criminal Code of Wisconsin provides that whoever is concerned in the commission of a crime is party to that crime and may be convicted of that crime although the person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of the first-degree intentional homicide by either directly committing it or by intentionally aiding and abetting the person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime as well as the person who directly committed it. A person who intentionally aids and abets the commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime, he either knowingly assists the person who commits a crime or is ready and willing to assist, and the person who commits a crime knows of his willingness to assist. To intentionally aid and abet first-degree intentional homicide, the defendant must know that another person is committing or intends to commit the crime of first-degree intentional homicide and have the purpose to assist the commission of that crime. Before you may find the defendant guilty, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of first-degree intentional homicide or intentionally aided and abetted the commission of the crime. All 12 jurors do not have to agree whether the defendant directly committed the crime or aided and abetted the commission of the crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of these ways. The defendant in the case is charged with first-degree intentional homicide, and if you must first consider whether the defendant is guilty of that offense, if you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of first-degree reckless homicide, which is a less serious degree of a criminal homicide. The crimes referred to at first-degree intentional and first-degree reckless homicide are different types of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by the law depends on the facts and circumstances of each particular case. Both intentional and reckless homicide require that the defendant cause the death of the victim. First-degree intentional homicide requires that the state prove that the defendant acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly under the circumstances which show utter disregard for human life. It is for you to consider of what type of homicide the defendant is guilty, if guilty at all, according to the instructions which define the two offenses. The statutory definition of first-degree intentional homicide. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant or a person with whom he was acting as a party to the crime caused the death of Teresa Hallback. Cause means that the defendant's act or the act of the person whom he was acting as a party to the crime was a substantial factor in producing the death. Number two, the defendant or a person with whom he was acting as a party to the crime acted with intent to kill Teresa Hallback. Intent to kill means that the defendant or a person whom he was acting as a party to the crime had the mental purpose to take the life of another human being, or was aware that the conduct was particularly certain to cause the death of another human being. While the law requires that the defendant or a person with whom he was acting as a party to the crime acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, or those of a person with whom he was acting as a party to the crime, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reasons for doing something, while motive may be shown as a circumstance to aid in establishing the guilt of a defendant or a person whom he was acting as a party to the crime. The state is not required to prove motive on the part of the defendant or a person with whom he was acting as party to the crime. In order to convict, evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Teresa Hallback with intent to kill, or are satisfied beyond a reasonable doubt that the defendant intentionally aided and abetted the commission of the offense, you should find the defendant guilty of first-degree intentional homicide. If you are not satisfied, you must find the defendant not guilty of first-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of 940.21 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after full complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement of the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in 940.021 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under the circumstances that show disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Number 1, the defendant or a person with whom he was acting as a party to the crime caused the death of Teresa Hallback. Cause means the defendant's act or the act of the person with whom he was acting as a party to the crime was a substantial factor in producing the death. Number 2, the defendant or a person with whom he was acting as a party to the crime caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant or a person with whom he was acting as a party to the crime was aware that his conduct created an unreasonable and substantial risk of death or great bodily harm. Number 3, the circumstances of a defendant's conduct or the conduct of a person with whom he was acting as a party to the crime showed utter disregard for human life. In determining whether the conduct showed utter disregard for human life, you should consider all the factors relating to the conduct. These include the following: what the defendant or a person with whom he was acting as a party to the crime was doing, why the defendant or a person whom he was acting as party to the crime was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, and whether the conduct showed any regard for life. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Teresa Hallback by criminally reckless conduct and that the circumstances of the conduct showed utter disregard for human life, or are satisfied beyond a reasonable doubt that the defendant intentionally aided and abetted the commission of the offense, you should find the defendant guilty of first-degree reckless homicide. You are not, in any event, to find the defendant guilty of more than one homicide offense. Mutilating a corpse, party to a crime, aiding and abetting the defendant either directly committed or intentionally aided the crime charged. Section 939.05 of the Criminal Code of Wisconsin provides that whoever is concerned with the commission of a crime is party to that crime and may be convicted of that crime although the person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of mutilating a corpse by either directly committing it or by intentionally aiding and abetting the person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime as well as the person who directly committed it. A person intentionally aids and abets the commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet mutilating a corpse, the defendant must know that the other person is committing or intends to commit the crime of mutilating a corpse, and have the purpose to assist the commission of that crime. Before you may find the defendant guilty, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of mutilating a corpse, or intentionally aided and abetted the commission of that crime. All 12 jurors do not have to agree whether the defendant directly committed the crime or aided and abetted in the commission of the crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of those ways. Section 940.111 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant or a person with whom he was acting as a party to the crime mutilated, disfigured, or dismembered a corpse. A corpse means the dead body of a human being. Number two, the defendant or a person with whom he was acting as a party to the crime mutilated, disfigured, or dismembered a corpse with the intent to conceal a crime. This requires that the defendant or a person with whom he was acting as a party to the crime acted with the purpose to conceal the crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, or those of a person with whom he was acting as a party to the crime, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, or is satisfied beyond a reasonable doubt that the defendant intentionally aided and abetted in the commission of the offense, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Second-degree sexual assault party to a crime, aiding and abetting the defendant either charged or either directly committed or intentionally aided the crime charged. Section 939.05 of the Criminal Code of Wisconsin provides that whoever is concerned in the commission of a crime is a party to that crime and may be convicted of that crime although the person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of second-degree sexual assault by either directly committed it or by intentionally aiding and abetting a person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime as well as the person who directly committed it. A person intentionally aids and abets the commission of a crime in acting with knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet a second-degree sexual assault, the defendant must know that another person is committing or intends to commit the crime of second-degree sexual assault, and have the purpose to assist the commission of that crime. Before you may find the defendant guilty, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of second-degree sexual assault or intentionally aiding and abetted the commission of that crime. All 12 jurors do not have to agree whether the defendant directly committed the crime or aided and abetted in the commission of the crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of those ways. Second-degree sexual assault, sexual intercourse without consent by use of threat or violence. Second-degree sexual assault, as defined in Section 940.2252A of the Criminal Code of Wisconsin, is committed by one who has sexual intercourse with another person without consent and by use or threat of force or violence. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Number one, the defendant or a person with whom he was acting as a party to the crime had sexual intercourse with Teresa Hallback. Number two, Teresa Hallback did not consent to the sexual intercourse. Number three, the defendant or a person with whom he was acting as a party to the crime had sexual intercourse with Teresa Hallback by use of threat of force or violence. The use threat of force or violence may occur before as part of the sexual intercourse. Sexual intercourse means any intrusion, however slight, by any part of a person's body or any object into the genital or anal opening of another. Emissions of semen is not required. Did not consent means that Teresa Hallback did not freely agree to have sexual intercourse with the defendant. In deciding whether Teresa Hallback did not consent, you should consider what Teresa Hallback said and did along with all other facts and circumstances. This element does not require that Teresa Hallback offered physical resistance. If you are satisfied beyond a reasonable doubt that the defendant had sexual intercourse with Peter Hallback without consent by use or threat of force or violence, or are satisfied beyond a reasonable doubt that the defendant intentionally aided and abetted the commission of the offense, you should find the defendant guilty of second-degree sexual assault. If you're not satisfied, you must find the defendant not guilty. Burden of proof and presumption of innocence. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, in your deliberations, you can find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt upon the state before you can return a verdict of guilty. The evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile that evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means any doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Information, not evidence, and information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence of the defendant in any way. It does not raise any inference of guilt. Evidence defined. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not the exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court is directed, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. You are to decide the case solely on the evidence offered and received at trial. The district attorney and the attorney for the defendant have stipulated or agreed as follows. Stephen Schmitz is a citizen living in New Holstein, Wisconsin, a community located 30 miles west of Manitowoc, Wisconsin. Joe Allen Zipper is a citizen living in the rural Manitowoc County of Wisconsin. That if called to testify, Stephen Schmitz would testify that on October 31st, 2005, Peter Hallback came to the Schmitz property to take a photo of a vehicle for Auto Trader magazine. Schmitz would indicate that the Hallback was at his residence at approximately 1:30 p.m., was there for approximately 10 minutes, was wearing a white t-shirt, waist-length jacket, and blue jeans. Schmitz would state that before leaving, Hallback provided Schmitz with the latest Auto Trader magazine and a bill of sale, left his property, and drove away in her SUV. Number 3, that if called to testify, Joe Allen Zipper would testify that on October 31st, 2005, Teresa Hallback came to the Zipper property to take a photo of a vehicle for Auto Trader magazine. Zipper would indicate that Hallback was at the residence between approximately 2 to 2:30 p.m., was there for approximately 10 minutes, was wearing a waist-length jacket and blue jeans. Zipper would state that before leaving, Hallback provided her with the latest Auto Trader magazine and a bill of sale, left the property, and drove away in her SUV. Zipper would finally state that the Avery salvage yard is more than a 10-minute drive from her residence in Manitowoc County. On October 31st, 2005, Bobby Dassey was the son of Barb Janda and brother of the defendant, Brendan Dassey. Bobby Dassey lived in the same residence with Barb Janda and Brendan Dassey at the time. That, if called to testify, Bobby Dassey would state that between 2:30 and 2:45 p.m. on October 31st, 2005, he was inside the Janda Dassey residence, where he observed a blue/green Toyota RAV4 stop outside the residence, in close proximity to the maroon van that his mother, Barb Janda, had for sale. Bobby Dassey would state that he observed a young woman that he later came to identify as Teresa Hallback exit her vehicle, take some photos of a maroon van, and walk towards the trailer of Stephen Avery. Bobby Dassey would further state that after taking a shower, he left the residence at approximately 3 p.m. to go deer hunting, at which time he still observed the RAV4 parked outside his residence, but that Teresa Hallback was not observed. Bobby Dassey would state that he returned to the residence at approximately 5 p.m. and no longer observed the RAV4. On October 31st, 2005, Scott Tiddick was the boyfriend of Barb Janda, knew the defendant Brendan Dassey, Stephen Avery, and other family members living at the Avery salvage yard. That, if called to testify, Scott Tiddick would state that between 7:30 and 7:45 p.m. on October 31st, 2005, he was at the Janda/Dassey property, where he dropped off Barb Janda. Tiddick would state that he observed a large fire in the burn area behind the detached garage of Stephen Avery. Tiddick would further indicate that at the time he observed Brendan Dassey and Stephen Avery standing next to the fire. Number 8, Dr. Jeffrey Jensen is the Chief Medical Examiner for Milwaukee County, Wisconsin, and is a board-certified forensic pathologist. Dr. Jensen agreed to be a medical consultant in this case and offered testimony as to the manner and cause of the death of Teresa Hallback. That, if called to testify, Dr. Jensen would state that after consultation with forensic anthropologist Dr. Leslie Eisenberg, he reviewed reports, photographs, x-rays, bone fragments, and other materials surrounding the Teresa Hallback death investigation. Dr. Jensen would testify that in his expert opinion, to a reasonable degree of medical certainty, the manner of death of Teresa Hallback was homicide, and the cause of death was a gunshot wound to the head. On October 31st, 2005, Angela Schuster was the manager for Auditrator magazine with headquarters in Milwaukee, Wisconsin. On the same date, Don Poliska performed duties as receptionist for Auditrator. That, if called to testify, Angela Schuster would testify that Teresa Hallback was hired as a photographer for Auditrade in October 2004 and continued in that employment through October 31st, 2005. Schuster would further state that Teresa Hallback had performed photo shoots at the Avery salvage yard on 5 occasions prior to October 31st, 2005, including June 20th, October 22nd, August 29th, September 19th, and October 10th. That, if called to testify, Don Pliska would testify that on October 31st, 2005, she received a phone call from Stephen Avery at approximately 8:12 a.m., at which time Avery requested that, quote, the same girl that had been out here before, and, quote, come to his property to take photos of a van he had for sale. Pliska would further state that Avery made the appointment under the name, quote, B. Janda, end quote, and that Pliska left a voicemail for Teresa Hallback at 9:46 a.m. asking if she could make the appointment. Number 13, that, if called to testify, Don Pliska would further testify that at 2:27 p.m. she did speak with Teresa Hallback on Teresa's cell phone, at which time Miss Hallback indicated that she was, quote, on her way, quote, to the Avery property from her previous appointment. You will consider that testimony in the same manner as if it had been given under oath here in court. Circumstantial evidence is not necessary that every fact be proved directly by the witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Confessions. Admissions. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence, in determining how much weight, if any, the statement deserves. Jurors' knowledge. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Remarks of counsel. Remarks of the attorneys are not evidence. If the remarks suggest certain facts not in evidence, disregard that suggestion. Closing arguments of counsel. Consider carefully the closing arguments of their attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. Exhibits. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence, whether or not it goes to the jury. Objections of counsel. Evidence received over objection. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of the witness and to the admissions of other evidence in which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made by allowing testimony or other evidence to be received over the objection of counsel. The court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Improper questions. Disregard entirely any questions that the court did not allow to be answered. Do not guess at what the witness' answer might have been. If the evidence itself suggested that certain information may be true, ignore the suggestion and do not consider it as evidence. Stricken testimony. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. Weight of evidence. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater evidence than that of other witnesses, or even of several other witnesses. Expert opinion testimony. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. You should consider the qualifications and credibility of the expert, the facts upon the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. In resolving conflicts in expert testimony, weigh the different expert opinions against each other. Also consider the qualification and credibility of the experts and the facts supporting their opinions. Credibility of witnesses. It is the duty of the juries to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight that you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial. The witness conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness testimony. The apparent intelligence of the witness. Bias or prejudice, if any, has been shown. Possible motives for falsifying testimony. and all other facts and circumstances during the trial which tend to either support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with the crime. Use the same factors to determine the credibility of the weight of the defendant's testimony that you have to use to evaluate the testimony of other witnesses. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience in everyday life. You determine for yourselves the reliability of the things people say to you. You should do the same here. Ladies and gentlemen, at this time, that concludes the instructions I'm going to give. Later on, I'll give a few more. Now is the time for closing argument. Counsel.
May it please the court, counsel, in our opening remarks to you, we asked you to think about two questions as you listen to the evidence, as you examine the evidence, as you evaluated the evidence. And those questions were, was he there? Did he help? In thinking about answering those questions, there's been a great deal of testimony, a great deal of information provided about the defendant, Brendan Dassey, and his uncle, Stephen Avery. But there's one other person here who's important, and that is the woman, Teresa Halbach, because this case is about her as well. And thinking about these questions, we pose them this way because there's an old maxim that seems to really fit. He who helps the guilty shares the crime. We're going to evaluate the evidence from another perspective. From what happened, the big picture, in the words of the defendant, and in the evidence that we presented. Then we'll look at what corroborates that. Why is it believable? Why is it reliable? What the defendant told us. And then we'll talk about the party to a crime. Specifically, why is he guilty of these offenses? That is it that he did that made him a party to the crime? And finally, we'll look at the evidence. We'll turn that prism and we'll look ever so slightly at the same evidence from another perspective. And that's the choices that he made, comparing what he did and what he didn't do. The choices that he made, the decisions that could have been made, that should have been made, but were not made. And those decisions, along with what he didn't do, along with what he did do, is the proof. All right. What happened? October 31, just like any other Monday, Teresa Halbach gets up. Seems like any other day, any other work day for her. Little did she know that this would be her last. You see, this day she was on the auto trader beat. She had a full day of appointments, an afternoon full of appointments. As you recall, the first appointment was with Mr. Stephen Schmitz of New Holstein. Mr. Schmitz, had he been called to testify, would have told you that Teresa Halbach was at his residence about 1:30, a 10-minute business transaction to place his vehicle in the Auto Trader magazine. And Teresa appeared with a waist-length jacket, a white shirt, and blue jeans. Upon the conclusion of their business, he provided her an Auto Trader magazine and a bill of sale. And Teresa moved on to her next appointment. And that with the zippers. You recall that if Joellen Zipper had been called, she would have told you that Teresa Halbach was at her residence in a rural Manitowoc County between 2 and 2:30. About that time, again, about a 10-minute transaction. Teresa was wearing a waist-length jacket, a white top, and blue jeans. And again, the transaction was brief and concluded with a copy of the Auto Trader magazine and a bill of sale. And as Ms. Zipper would have told us, it's about a 10-minute ride to her next appointment. That appointment was with B. Yonda, which we all now know was the appointment with Stephen Avery. The appointment with death. Little did she know what awaited her. Let's look at the evidence more closely. Remember, about 2:27 now, Teresa calls into Auto Trader to Dom Pliska. Says, I'm on my way to my next appointment. It's a 10-minute ride thereabouts. Somewhere between 10:35 and 10:40, Teresa Halbach arrives. And at 2:41 in the afternoon on October 31st, Teresa makes her last call. You recall Exhibit 56, the singular records documented her very last call at 2:41. As you recall from the other stipulations reached, at about 2:45 p.m., Bobby Dassey's getting up, getting ready to start his day. He looks out the window, and what does he see? Called to testify, he would have told you that he observed a blue-green Toyota RAV4 stop outside of his residence in close proximity to the maroon van that his mother, Bob Yonda, had for sale. He would tell you that he saw a woman that he later learned was Teresa Halbach exit her vehicle and take pictures of that van. Now, remember, this is 2:45. She concludes with the pictures, and where does she go? Bobby Dassey tells us that she was walking toward the residence of Stephen Avery. He takes his shower, he gets up, and he hits the road at 3. He likes to go hunting before he goes to work. He leaves at 3, and what does he see? He doesn't see Teresa, but her vehicle is still there, the RAV4. When he comes back at 5, Teresa is nowhere to be seen, and neither is the RAV4. And we now know, based on the words of the defendant himself, that Bobby Dassey was not the last Dassey to see Teresa Halbach alive. An hour passes, an agonizingly slow hour for Teresa Halbach, no doubt. You see, she's been overcome. She's now handcuffed, leg cuffed, and spread eagle on the bed of Stephen Avery so that he can have his way with her. Into the defendant, Brendan Dassey. You will recall there's no disputing that he got off the bus at 3:45, again about an hour after her arrival on the property, with his brother, Glen, and they head up to the driveway to the house. As you might expect, as usually happens in families, the older brother gets his way, and Blaine gets the computer and the phone first to arrange his night's plans. And the defendant watches TV for a while and then goes out to get the mail. He goes down and gets the mail. And he's coming back to his house, and he looks at it and says, "Oh, I got something here for Uncle Steve. Well, I'll just take it over there." So he goes over to Stephen Avery's trailer, and he's knocking out on the door. He hears screams for help, and he's knocking. And he told us in his statement it takes 5 minutes for his uncle to answer the door. And when he does, what is his observation? Stephen Avery is dressed in red shorts, a white t-shirt, and sweating. "Come on in, Brendan." So he goes in, and in a matter of moments, he begins to understand what's occurring, what horrors are occurring in that room, because he can look down that hallway and see Teresa's body on that bed, at which time Uncle extends a most gruesome invitation. "Do you want some?" he says. They talk. The defendant is trying to decide, well, I don't know. I'm too young. I'm not ready for this. "Do you want some?" That's between 4 and 4:30. But it's starting to get late now. The defendant knows he's got to get home because his mother's going to be home at 5 and Blaine is home. Got to find out what's going on. So he goes home and has dinner with his brother. He talks to his brother. His mother comes home and he talks to his mother. And he learns that she's going to Green Bay to see the mother of Mr. Taldiuk. He knows that his brother Blaine is going to trick-or-treating. So what does the defendant decide to do? He decides to return to Stephen Avery. He decides to take him up on that invitation. But before he does, he gets a call. He gets a call from Mike Cornley. I think Mr. Cornley was off maybe half an hour. He gave us an hour in which that call was made. He thinks 6. I think that call came closer to 5:30. The call probably came in at 5:30. And Brendan clearly did talk to Mike Cornley. We have no dispute about that. But he leaves and goes back. We know he goes back. We know he goes back because he tells the police he goes back. We know he goes back because he tells his mother in those phone conversations 10 weeks later on May 13 and May 15 that he went back, that he was there. And we also know through the other fact, he knows that Avery's fiance, Jody Stokowski, calls, and she told us that she called the first time about 5:30. So we know he went back. Meanwhile, back at the Avery trailer, Teresa remains a prisoner, and we can only imagine. But the defendant, this man, he goes back. Why? Because he wanted sex. Because he wanted to know what it was like. Because he decided he made his first choice to accept the invitation. So he goes back and he rapes Teresa Halbach while his uncle watches and applauds his efforts. Attaboy, Brendan. That's the way you do it. Does that sound like something you'd make up? So they go back up to the front room and they talk about their deeds. But more importantly, they talk about what are we going to do next? Well, the answer is obvious. They decide to kill her. They go back to the bedroom. Stephen Avery stabs her in the stomach. He hands the knife to the defendant. Says, "Here, cut her." And the defendant, he tells us he does. Right across here. Tells us that Mr. Avery chokes her to the point of unconsciousness. The defendant is then told to cut off a lock of her hair. A souvenir, no doubt. She's unconscious, then cuff her. They tie her up and they carry her unconscious body to the garage. And then Stephen Avery gets another monstrous idea. I know, instead of burying her in a nearby pond, we'll burn her. But first, Brendan, you wait here. I got to go back and get the gun. And at that moment, the defendant becomes the silent sentinel for the last moments of Teresa Halbach's life. Stephen Avery returns to that garage and shoots her 10 or 11 times on the floor of that garage. And in a blink of an eye, the killers have become pallbearers, carrying her and put her on the blackjack creeper to the fire that's already started, to the fire that's already ready to go under the cover of darkness, to a bonfire that's common on that property, carrying her to the funeral fire. Only this is not a funeral fire of days of antiquity where the family and friends came to and honor the dead for their life. This was not that. That was an incineration. It was not conducted to honor her. It was conducted to destroy her. It was conducted, more importantly, to destroy the evidence of these heinous acts. Moments pass, and it's time to clean up. It's time to cover up. The SUV is taken down to the other part of the salvage yard. It's covered with brush and a fence post with brush, the hood of a car, all part of a plan to cover up these acts. Then it's back to the fire. What are we going to do? Now it's time for the fire to be tendered. More tires, more wood, more brush. A van seat are all thrown into the fire to conceal the horrific acts that they have done. Now, let's step back for a moment. It's about 7:30 to 7:45 now. The defendant's mother is returning with Scott Taddick from Green Bay. And you recall the stipulation. If called to testify, Mr. Taddick would state that between 7:30 and 7:45 on October 31, he was at the property where he dropped off Bob Yonda. Taddick would state that he observed a large fire in the burn area behind the detached garage of Stephen Avery. Taddick would further indicate at that time he observed Stephen Avery and the defendant standing by the fire. Time passes, but there's more cleaning up to be done. There's more cover-up to be done. The floor of the garage where the shooting occurred had to be cleaned up with paint thinner, with gasoline, with bleach. Bleach. Why would you use bleach to clean automotive stains off the floor of a garage? You wouldn't. But if you're Stephen Avery, you would know how to use bleach to destroy the evidence. What else is destroyed? Her clothes. There wasn't just a bag of rags that was used to clean up. Teresa Halbach's clothes were used to clean that up. And they were thrown into the fire along with the bedding. And just as Teresa and her clothes were burned, just as her personal effects of earlier disposed of in the burn barrel, the camera, the cell phone, and the like, her purse, her Palm Pilot, and all that burned. Eventually, the killers have to go back to the fire because the consumer body requires a great deal of heat, more tires, more fuel, and they go back and they tend the fire. And they watch the fire, and they must have thought that they were home free. But we know they were not, because Teresa's remains here are a silent witness to the killer's deeds. Tom Sturdivant, Rod Pevito, Leslie Eisenberg, Dr. Jeffrey Jensen would see to that. As you recall Dr. Jensen's stipulation, he would have told us in his expert opinion to a reasonable degree of medical certainty that the manner of death was homicide, the cause of death was gunshot. All right. Now, the question is, why should we believe the things that the defendant told us? Let's talk about corroboration. Teresa Halbach was in Stephen Avery's trailer on October 31. How do we know? His trailer was searched. And what did we find? An Auto Trader magazine and a bill of sale. Just the same information that Stephen Schmitz was given that Joellen Zipper received. Teresa Halbach was restrained in Stephen Avery's trailer. How do we know? Handcuffs. Handcuffs and leg irons. Restraints. Teresa Halbach was shot in the garage. How do we know? Well, remember, there was a search warrant that was issued shortly after the defendant gave his statement, his confession. We have a bullet fragment from a .22 caliber. We have shell casings, 11 shell casings, a shell casing that was discharged from this weapon, bullets discharged from this weapon, a .22 caliber Martin Glenfield rifle, the very rifle that hung on the rack of Stephen Avery's bedroom, the very rifle that fired the bullet, which was found right there, and a bullet number 23 found in the garage, the bullet with the profile of Teresa Halbach. Her DNA is on that bullet. Now, let's think about that for a minute. That rifle was effectively seized by 11 a.m. on Saturday, November 5, when the SUV was discovered on that property, because law enforcement had control of those premises. It was collected into evidence the next day, Sunday, the 6th, as the testimony revealed. Now, that gun is the only gun that could have fired that bullet with Teresa Halbach's DNA on it. All right? Well, we know Teresa Halbach was alive on Monday morning. We know she was alive on Monday afternoon. So that bullet with her DNA had to have been fired from that gun between Monday afternoon, October 31st, and Saturday the 5th, because how else does that bullet get into that garage with her DNA on it? The bullet gets there because it comes from the gun of Stephen Avery, from the shots fired by Stephen Avery, only this man, the defendant, knows. He told us that she was shot 10 times. That's pretty close. As we say, we have 11 cartridges. She was shot with a .22 caliber rifle. We have a .22 caliber rifle. And what else did we find in the search? More ammunition. .22 caliber long rifle magazine, mini mags found in the trailer of Stephen Avery. Teresa Halbach was shot in the head twice. She was shot on the left side of the head. How do we know that? Well, we have 2 bits of information. Dr. Leslie Eisenberg, the forensic anthropologist, told you that she examined the cranial fragments and found not 1 but 2 fragments that showed internal beveling consistent with a projectile, consistent with the bullet entry wounds to the left side of the head. Remember? The parietal bones. And into the back of the head, the occipital bone. There's an example of the cranial damage to the parietal bone right there, a bullet entrance wound. X-rays. Remember the testimony of Mr. Olson? There's an X-ray from the parietal that's inside pictures. Traces of elemental lead. Well, lead comes from bullets. There's the parietal and the occipital, left side of the head and the back side. Teresa Halbach's body was loaded into the rear of the SUV after she was shot. How do we know that? The defendant told us that they did that. Well, we have Sherry Culhane and Nick Stalkey to tell us about that. This particular photograph here shows the presence of a stain on the right rear well plastic molding. The stain that Mr. Stockton told us was consistent with hair, with bloody hair. But that's not the only blood in the back. We have the cargo door, the tailgate area where you have impact stains. You have dropping passive gravity stains, all blood stains, all blood belonging to Teresa Halbach. Clearly corroborating the fact, as the defendant told us, that her body was placed in and out of the vehicle. He told us that her body was burned. It was mutilated in a fire pit behind Stephen Avery's garage. How do we know? Well, let's look at the side of the general layout. We have the defendant's trailer, the van, Mr. Avery's trailer, and the burn area all in immediate close proximity. And you remember the defendant told us it only takes a minute to walk between his place and Stephen Avery's. The burn area contains human remains. Remember the silent witness. Thomas Sturdivant and Rod Pevito. Mr. Sturdivant, the one who began to find remains of Teresa Halbach. The remains which were provided to Dr. Eisenberg from this burn pit, just as the defendant said. Dr. Eisenberg told us this was the first bit of forensic evidence from that fire pit. Now, all of you have to do is look at that box. These are the remains of Teresa Halbach. If that's not mutilation, if that's not burning to the point of mutilation, to the point of destroying as best they could her remains, I don't know what is. Remember, Mr. Pepito is telling us, Dr. Eisenberg and Sherry Cohane, this piece of bone recovered from the pit and the muscle tissue of Teresa Halbach. This was tested, and the DNA confirms a match to Teresa Halbach. There's no doubt that it is her remains in the pit, just as the defendant told you. But, as if that's not enough, do we have any more? Dr. Eisenberg told us that there were representative samples from almost every bone in the skeleton of Teresa Halbach that was found in that burn pit. You remember this photograph? She was assisted by Trooper Alston from the Wisconsin State Patrol, who put together this diagram reflecting the bone fragments which were recovered from head to toe. There was no doubt that she was burned in that pit, that she was mutilated in that pit. And if we needed more, we have more. Dr. Simley, tooth number 31, the molar. He fractured matched it together, compared with dental x-rays he received from Teresa's dentist, and was telling you that it was very consistent, highly consistent with Teresa Halbach. So, you have DNA, you have the defendant telling us, you have dentist confirming all what the defendant told us. It is her remains in that burn pit. He told you that the van seat and the tires were thrown upon that fire. Is there any doubt of that? There is no doubt. Remember the testimony, of Special Agent Pevto, with 27 years of experience in the Arson Bureau for the Wisconsin Department of Justice, examining more closely the pit and its remains. And what did he tell us? He told us many things. Steel-belted wire from radial tires were harvested from that pit. And when he observed that wire, there were bone fragments in that wire. So we know the tires were used to consume Teresa Halbach. We also know the tires were used, but he could tell you that encrusted like surfaces of the ground from tires being consumed, melting down from the smell, he could confirm that these were tires. He also commented on this Exhibit 170, the implements of mutilation. You can still see wire from the steel-belted radial tire. There's the picture from the scene as it was. You can see a tire in the background and the van seat. And as Agent Pevito told us, this ball of wire right here is steel-belted radial tires, and that spool of wire were more remains when he first saw them of Teresa Halbach. He said there were many tires, multiple tires, at least 5, probably more. Who knows how many radial tires that weren't steel-belted that were used in the incineration of Teresa Halbach. He told us that fire excellent source of fuel. But he also told you about the van seat. This van seat, a van seat for all the intents and purposes, is going to take 2 people to pick up and put on the fire. Agent Pevito told you that this polyurethane in that seating is like gasoline. It's fuel that's roughly equivalent of the fuel in the tires. That you're going to get quite a blaze from a tire. You can have a couple of tires and have a flame that's going to go back and forth 3, 4, 5 feet. A couple more tires, you might have one that's going to go up 9 or 10 feet with a great deal of heat, enough heat to consume a body. The defendant told us that Teresa Halbach's SUV, her RAV4, was driven up to the pit area, as they call it, to the salvage yard, to a point in the yard as far away from the Avery's trailer, far away from the defendant's trailer, in the far corner. The defendant told you in his confession that the vehicle was covered with branches and a car hood, as we talked about earlier. Well, we have the pictures upon recovery that night. There's the car hood, the fence post, and the other items. Earlier in the day, upon its initial discovery, another view, branches on the top, boxes, cardboard, there's a hood, just as the defendant told us. The license plates were removed. You recall the testimony and the stipulation. They were found by a firefighter in an abandoned car on that property. But here's a key point. In that statement, the defendant tells us that Stephen Avery opened the hood of that vehicle. How do we know? Well, based on the statement of March 1, they swabbed the hood and obtained a DNA profile of that hood. A DNA profile of Stephen Avery. Only the killer and his accomplice would know that, to look there, because law enforcement had not looked there before. And not until he told them is that why they found this. The garage floor was cleaned with gasoline, paint thinner, and bleach. Remember the testimony, of John Ertl. Mr. Ertl told us that one of his duties for the crime lab is to come in and check areas for possible bloodstains residue. And one of the tools that they use is a spray called luminol, because it reacts to a number of items, but more importantly, it reacts to blood. When asked, what does it react to? He said bleach. It reacts vigorously, I believe was his word, to bleach, just as it does to blood. Although subsequent testing found no blood, the luminol reacted to bleach. Bleach used to clean the stain in the garage. Paint thinner, bleach, recovered items. But here's a critical fact. The defendant's blue jeans, Exhibit 58. Those certainly look like bleach stains to me. The defendant told us, the officers, on March 1st, before he gave his statement, that these were the pants he was wearing when they asked him, "Hey, we heard you from somebody that you had bleach on your pants." He said, "Yeah, there's a bleach there are the pants." Now, it seems to me the last time that I spilled bleach on any of my clothes, unless I knew it, unless I saw it, you don't really recognize that there's bleach on there until they're washed. The defendant is trying to sell you a bill of goods saying, "Well, I didn't bend over, I didn't get dirty, but I decided to wash my pants even though I just put them on an hour or two earlier." I don't think so. The defendant told you that the key for Teresa's vehicle was put by Mr. Avery in his bedroom. The key was recovered in a search in the defendant's bedroom. Now that search occurred on November 8th. Teresa Halbach's clothes. He told us that they were burned in the pit. But why should we believe him? Well, we have 5 Daisy Fuentes rivets recovered from the burn area. We know that Teresa Halbach had a pair of Daisy Fuente jeans from her sister Katie, Exhibit 13. A pair very much like these. A pair with 6 rivets. Rivets that looked just like that. You remember Agent Sturdivant telling you about a zipper pull? Also, that he found when he first began searching that burn area on November 8th. So we have a zipper pull, we have Daisy Fuente rivets, and I think also has some grommets that are no doubt from her shoes. The defendant told you that his uncle's finger had a cut on it at the time the SUV was hidden in the corner of the salvage yard. All right, there's multiple points that corroborate this. A search of the defendant, Stephen Avery. You recall this picture with the cut on his hand. Interestingly enough, the right hand. The hand that you would put a key if you're going to start a car with your right hand, and you would put it in that ignition. And where is the stain? Right next to the ignition. Right there. Right here. Ignition is right there behind the steering wheel, and there's the stain. So if you were actively bleeding, that's where you would expect to see blood, right where you would expect to see it. But there was blood elsewhere. Remember, Stephen Avery's blood was on the CD case, on the car seats, corroborating the fact that he was actively bleeding, that did have a cut on that day that the vehicle was hidden. We have a burn barrel contents. Defendant said he saw items in that burn barrel. Well, we know that he was right because recovered from that burn barrel were various electronic devices, or at least their remains. A Canon A310 power shot camera, a Motorola Razr phone, a Palm Pilot, all recovered from the barrel. These things that only the killer would know. We have a couple more. We have more corroboration. Jody Stokowski testified that she called Avery twice on October 31. The defendant told us that she called twice on October 31st. Before we get to that, we even have more points. It's almost like it's the elephant in the room that's no one's paying attention to for corroboration. There are 2 points. The richness of the detail provided by the defendant in that confession tells us that it's true. You can't have that rich of a detail unless you were there, unless you experienced it, unless you lived through it. And another one is that fact that everything he said in that story corroborates Stephen Avery's involvement in this. There was nothing inconsistent that suggested anyone else other than Stephen Avery was his partner in this heinous act. All right, party to a crime. What he did. Let's talk about that. First degree intentional homicide, mutilation of a corpse. Second degree sexual assault. We'll talk a little bit about party to a crime before we review specifically how the evidence applies to the defendant. One is a party to the crime if they directly commit it or intentionally aid and abet the person who's committing that crime. The court has just instructed you, and let me emphasize, a person intentionally aids and abets the commission of a crime when acting with the knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person, he helps the person, or is ready, willing to assist the person who's doing the act, knows a willingness to assist. All right, so let's talk about that knowledge component. Think back. He opens the door, and he knocks, and he hears screaming. He hears screaming for help. He goes in, and he sees her tied to a bed, cuffed, spread eagle, and he hears the words again, "Help me." Clearly, there's knowledge right there. He knows there's a crime afoot. Whatever's happening, it isn't good, and he knows it. The critical fact is the invitation by the defendant. The invitation to have sex with Teresa Halbach. The invitation to rape her, and he chooses. He decides to accept, so he participates. He directly commits second-degree sexual assault because he rapes her. He assists, he helps kill her. He rapes her. He cuts her throat. Remember, the defendant stabs her in the stomach, and he gives the knife to the defendant, and he says, "Cut her." He cuts her. He helps uncuff her. He holds her down to make sure she doesn't try to get away after they stabbed her and choked her so that she can be tied up. He helps carry her to the garage. He helps put her in the RAV4 after Avery shoots her. He watches her a while and gets the gun. He helps carry her on the Blackjack Creeper to the fire pit, and he helps throw her on that fire. He helps putting fuel on that fire. Tires, wood, brush, and van seat, all affirmative acts, all the things that he did. He helped. He gets the golf cart so that to make it easier to collect the van seat, a wood cabinet, and whatever else, and tires, got to work fast before everyone gets home. And he watches. He's ready, willing, and able to assist Stephen Avery tend to the incineration of Teresa Halbach. He's there. He knows what's going on. He saw the body parts. You bet he did. And he told you, his cousin, that he did. We know that to be true. Now, before we get to that, let's talk a little bit more about the jury instructions. First-degree intentional homicide. The defendant, or a person with whom he was acting, in this case Stephen Avery, caused the death of Teresa Halbach. There is no doubt. Cause means the defendant's act or acts, or the person with whom he was acting, was a substantial factor in producing her death. Well, cutting her throat, tying her up, and carrying her to the garage so that Stephen Avery can shoot her is certainly a substantial act in furtherance of her death, a substantial factor in producing her death. Clearly, they intended to kill her. After they're done raping her, they have a little chat in the front of the room to decide what they're going to do next. That's the point. They decided to kill her. That's the point where he had the knowledge. He knew that they were going to commit a crime. He knew that they were going to kill her because they had to kill her because she had been to the Avery salvage yard many times before. She knew her killers. She certainly knew Stephen Avery. So to cover up this sexual assault, they had to kill her, and they did. There are the acts. Now, I'm going to comment on, you've been given on what we call in the trade, a lesser included offense called first-degree reckless homicide. Clearly, at minimum, his behavior is reckless. It's clearly utter disregard for human life, the callousness by which he conducted himself, turning a cold ear for her pleas for help. Don't do it. Do the right thing, please. But he turned a deaf ear and he didn't do the right thing. He wanted to do what he wanted. Well, that, at minimum, that is clearly beyond reckless. The evidence calls for a verdict of guilty on first-degree murder as a party to a crime. He helped kill her. And while it's true that we make no bones about it that Stephen Avery was the one who fired the gun, he was clearly assisted by Brendan Dassey. There is no question on the mutilation of the corpse. Why? You have to burn the body. We got to get rid of the evidence. Fire is better than discarding a body in some pond somewhere nearby. A fire will consume the remains. There will be nothing left. We'll get away, or so they thought. Second-degree sexual assault only requires two elements. Did he have sexual intercourse with her, and did he do so without her consent? Well, I think without consent is pretty apparent here. And he told you. He didn't have to tell you. The whole confession, he could have laid it all on Stephen Avery. But he didn't. He didn't have to admit that he raped her, but he did. We know he did. We know he did it. All right. Now, let's look at the evidence from another perspective. Let's look at the evidence from the perspective of what he didn't do, of the choices he made, because it's important. While we're free to choose our actions, we're not free to choose the consequences of our actions. And this is about the consequences. This is about justice. What's the first choice as we go back and think about the evidence? What was the first choice he really had to make here? Well, remember, it's between 4 and 4:30, and he's over there at Stephen Avery's trailer, and he sees her tied to a bed. He's asked, "You want some?" It's decision time. Well, he could have tried to rescue her, but I'll grant him that. He's not going to pull that off. We all know that. But that were his choices that he had. He could run, leave, call 911. He could just say, "Uncle Steve, you can't do this." He could have at least tried to talk him out of it. He could have simply left and said no to the invitation. And when he got back at 5, he could have told his mother. As we know in the call, as she rightly noted, "I would have helped you, put you in the car, and we would have left." The defendant was not someone who was in the wrong place at the wrong time. He was in the right place at the right time. He was the only person who could have saved her, and he chose not to save her. Why? Because he wanted to know what it was like. That was the choice he made. A second choice, showing his complicity. He didn't have to go back. Remember, He's home at 5. He hadn't done anything yet, but see what was likely to happen. He hadn't done anything but receive an invitation. At 5, he didn't have to go back. He could have told Blaine. He could have told his mother. He could have, I got to go trick-or-treating, Blaine. You take me with you. Or, Mom, can I go with you? But he didn't. He chose to go back. That's the decision he made. The third choice. Okay, he's still got a chance to rape her or not rape Teresa Halbach. Try to rescue her probably wouldn't have been too successful. He could have ran and called 911. He could have left. Or, what? At least he could have said, he could have said no. But he didn't. He chose to rape her. Even with her saying, don't do it, do the right thing, tell him to stop. But he didn't. So think about the decisions that he had to make along the way, just in a matter of moments. He's got to go into that room. He's got to take his shirt off. He's got to take his pants off. He's going to take his shoes off. He's going to take his underwear off. And he's going to climb on that bed and he's going to penetrate her. All the steps along the way. Decisions. Stop anywhere. Say, no, I don't want to do this, Uncle Steve. But he didn't. He gets done and they go into the other room and he gets instead of making a call, instead of receiving the thanks from the Halbachs, instead of receiving the adulation from the family for reporting this crime and saving their daughter, instead of receiving thanks from them, he's receiving thanks from Stephen Avery. Attaboy, that's how you do it. That's the choice. He could have chosen thanks from the Halbachs, but he chose thanks from his uncle. Fourth choice, the decision to help kill her. All right. He had already found out that what he wanted to know. He found out about sex. He didn't have to kill her. Could have let her go. At least a conviction for rape is better than a conviction for murder. You could have called 911, couldn't you? You know what? At that point, he probably wasn't going to call 911, but he could have said, no, I don't want to do it. He could have left. He could have gone back to his trailer, but he didn't. So he decides. He goes back into that bedroom. His uncle stabs her, and he takes that knife and he cuts her throat right across here above the Adam's apple. Instead of saying no, instead of leaving, that's what he chooses to do. There's a second part. He also chooses to help carry her to the garage. He chooses to help uncuff her, to hold her down while Uncle Steve ties her up. He helps carry her to the garage. He could have said no. He could have ran out the door and said, I can't do it anymore. I just can't do it. This is wrong. But he didn't. Put her in the SUV, or on the garage floor, and he's left alone with her. Now think about that. He's left her alone for a moment or two, probably a minute. He knows from their conversation that Avery's going to go get that gun. He could have ran out that door. He did not have to be there, but he stayed as a silent sentinel for Teresa Halbach's last moments while his uncle fired all 11 shots into her body. The final choice was his choice, to help dispose of the body, to help cover up this crime, to lie about it. He gets the cart. He gathers the fuel, just as we said, and they burn her. They incinerate her in their effort to destroy evidence. The mutilation was made and done for the purposes of concealing these brutal, heinous acts. That's why the corpse was mutilated. That's why it was burned. That's why the fire was tended with a shovel and rake to rake up into pieces, to create more surface area to burn the body quicker, more effectively. The cleanup and cover up. Let's clean up the garage. Let's hide the SUV. Let's burn the bedding. Let's burn her clothes. Could have stopped anywhere, but he didn't. And if he is as innocent as he would have you believe, he didn't have to lie to Detective O'Neill. He who helps the guilty shares the crime. Was he there? Absolutely. Is there any doubt? This is beyond any doubt. He clearly was there. The richness of the detail, the corroborative evidence, answers that question as it does the second. Did he help? Did he assist? Was he ready, willing, and able to assist? Yes. Did he assist? Yes, he did. Did he help? Did he help Teresa Halbach? No. Did he help Stephen Avery? Absolutely. The defendant cannot escape the responsibility for his actions by claiming that they were the ideas, that it was the fault of Stephen Avery, because, in essence, this case comes down to this very point. The invitation to participate in these monstrous acts clearly speaks to Stephen Avery. No doubt. But this case isn't about the invitation. This is about the acceptance of that invitation, and the acceptance of the invitation speaks to the defendant, Brendan Dassey. The evidence calls for verdicts of guilty of first-degree murder, for the second-degree sexual assault, and for mutilation of a corpse. A weakened sense of responsibility does not weaken the fact of responsibility, and there's only one verdict, the verdict of guilty. We ask you to return on those verdicts. On behalf of the prosecution team, Mr. Gratz, Mr. Gahn, and Mr. Bassbender, and Mr. Wiggert, we thank you for your time and your consideration.
All right, we'll recess until 2. Ladies and gentlemen, again, I'll advise you the time for deliberations has not yet arrived, so don't discuss this or anything about the case amongst yourselves. All right, we're adjourned. Good afternoon. Is the defense ready to proceed?
Yes, Judge. Thank you.
Go ahead.
In the opening, I explained to you that a good example of a trial is a novel. There's a...
Counsel, you may wish to turn the microphone on.
Oh, thank you very much. Can you hear me? Okay, sorry about that. I don't know if you're familiar with Sherlock Holmes. I tend to like Sherlock Holmes novels, and there's a novel called The Memoirs of Sherlock Holmes. And it's actually kind of a compilation of stories, and one of the stories is called The Silver Blaze. And if you're familiar with Sherlock Holmes and Sherlock Holmes stories, there's two main characters. There's Sherlock Holmes, who is the intelligent private detective, and there's Dr. Watson, his sidekick, who he often has do the grunt work. Dr. Watson goes and collects statements from witnesses, talks to the police. Dr. Watson is the one who is essentially doing all the legwork. And in The Silver Blaze, Dr. Watson goes and talks to all of the witnesses and the police officers. And he comes back to Holmes, who has a tendency to sit there and puff on his pipe while he's listening to Dr. Watson. And he starts puffing away as Dr. Watson explains and runs down. That is what we know. We know this, we know this, we know this. And as he's talking, Sherlock Holmes interrupts him and says, "Well, what about the dog?" Watson doesn't understand and just continues to keep reciting what he's learned from the investigation. And he begins to continue to recite the investigation. And again, one Holmes interrupts and says, "Well, what about the dog?" Finally, Watson says, "Holmes, what do you mean about the dog?" And Holmes says, "What did the dog do?" Watson starts sifting through his notes and turns to Holmes and says, "The dog didn't do anything." And Holmes says, there you have it. I know who's the killer. The killer is a person the dog knows." Essentially, what Holmes, the story in Silver Blaze, is that Holmes was able to determine that it's not necessarily what you know, it's not necessarily what you see and what you hear. Sometimes it's what you don't see and what you don't hear that's as important. And that's something that I wanted to touch upon in this case. There's a lot in this case that we don't know. There's a lot in this case we don't see. And there's a lot in this case that we don't hear. Much has been talked about DNA, and the state focuses on DNA in their closing. They talk about it in the trial. They have witnesses, several different witnesses, that explain what DNA is. Sherry Culhane, Nick Stalkey. DNA is a very important aspect of this case. But what we know is that they tested over 180 items, over 500 items submitted to the crime lab, not all for DNA, but items individually. What we do know about the DNA is that none of it matches Brendan Dassey. We do know that there are handcuffs and leg irons that were found in Stephen Avery's residence, the same handcuffs and leg irons that the state brought out to show you, the same ones that have Stephen Avery's DNA on them, but nothing with Brendan Dassey, or Teresa Halbach for that matter. There is no evidence of DNA matching Brendan Dassey on any of the evidence that's submitted to this court, to you jurors to consider. Nothing on the rifle that was used, according to the state, according to the witness, to shoot Teresa Halbach. There is blood in Stephen Avery's house. They find it on the molding, but that's not Brendan Dassey's. They find it in his bathroom, but that as well is not Brendan Dassey's. We do know that they decided not to test certain items, the creepers. Now, the creepers seem to be a pretty significant piece of evidence for the state. But what we do not hear and do not see is any evidence that suggests the creepers were actually used by Brendan Dassey. Mr. Fallon mentions in his closing argument that this is how it happened. He analogizes it to a funeral procession, using the creeper to move the body from one place to another. But there's no blood found on the creeper, and yet, as important a piece of evidence that this creeper apparently is, if it's brought up by the state as being the item that moved this body to the burn pit, why is it not tested for DNA? The answer we received from Sherry Culhane was, no one asked her to. No one asked her to test it for DNA. She looked for blood. That made sense because the theory of the state's case is that this piece of evidence, this creeper, about 3-4 feet long with wheels, was used to wheel Teresa Halbach to the burn pit, yet they decide not to even test the creeper for DNA. The knives. She indicated that they received a number of knives. The police went through Stephen Avery's house, took out every knife in the kitchen, sent the items down to the crime lab. The crime lab looked for blood, and that was it. There was no blood on them, so they stopped. Why? They were not told to test for DNA. Now, the state points out during the trial, when asked questions of Sherry Culhane, well, could it have been wiped clean? And she said, sure. Would you have been able to obtain DNA if it had been wiped clean? Probably not. But the bullet had no visible blood, and she talked about how they washed the bullet to be able to tell if there was DNA, and that they did find DNA, Teresa Halbach's DNA. So it is possible. Why did they choose not to wash the knives? They chose not to. Brendan's jeans. They had bleach on them. They appeared to be a significant piece of evidence. The state pulled them out, showed you the jeans again. When they tested it, they found no blood. If he were crouched down on the ground, as was presented to you by one of the state's witnesses, why isn't there blood? They could have tested for DNA, but again, they chose not to. Didn't find the blood. They chose not to test. And the hairs, again, they chose not to test. It's too difficult, too much. They went through yards and yards of soil. You saw the pictures. 3, 4, 5 crime lab technicians digging through the soil to find minute pieces of bone and teeth, which they found. The box that Mr. Fallon referred to, showed you the picture of. They found minute pieces of bone by sifting inch by inch, piece by piece through the dirt. But the officer said it was just too difficult to go through hundreds or thousands of hairs in a vacuum. Again, that was their choice not to fully investigate and fully corroborate Brendan Dassey's statement. The shell casings on the garage floor and the Rambler hood, if I recall, I believe that the first technician from the crime lab, Mr. John Ertl, came, testified, indicated that when he arrived at the Avery salvage yard, the first thing he noted with the RAV4 was that it might need to be taken immediately to the crime lab because of the inclement weather. One thing he also noted was that instead of processing the Rambler hood and the cardboard box on top of the RAV4, they sent it down immediately with the RAV4 to be processed, fingerprinted, checked for blood. Stephen Avery has this cut finger and he's leaving blood throughout the entire RAV4. Certainly there should be or maybe some on the Rambler hood. Rather than process it on the field, they sent it to the crime lab. That was the intent of the crime lab tech. Was it ever checked? No. DNA person indicated, no one asked me to. The fingerprint analysis, no one asked me to check for fingerprints. 2, apparently, vital pieces of information, pieces of evidence that one of their own crime lab technicians sent to the lab, they chose not to test. The bedding and the carpet. The bedding and the carpet is important to note that despite the statement where Brendan indicates in his statement to the officer that bedding was thrown into the fire, there was other bedding that was taken. The investigators felt it was necessary, important enough to look at, but not tested. The carpet, never tested, never checked. The the crime lab witnesses all indicated we would have checked had someone told us. So this investigation, they chose not to test items that didn't match with their theory. They'd already decided what happened in this case. They needed to prove their theory. The hairs, they're not going to help their theory. The vacuum's not going to help. Only time they would have looked for DNA is when there was blood or the bullet. The fingerprint analyst testified that he did print Brendan. He also found a number of different prints throughout the RAV4, and including on the outside of the RAV4, where one, you would suspect if they're placing brush, a wooden post, a hood, would have placed their hand upon it. And he was able to actually detect a print. He was able to actually process the print, save the print, and compare the print. And when he compared the print, didn't match the print they had for Brendan Dassey. None of the prints within the vehicle matched the print they have for Brendan Dassey. The fingerprint analyst indicated that he could have checked the handcuffs. It was a smooth surface, wasn't rusted. He could have looked for fingerprints, but no one asked them to. Could have looked at the leg irons, smooth surface, but no one asked them to. The creeper. He could have looked at the creeper if the creeper were used by Brendan Dassey. If Brendan Dassey actually helped use the creeper to move Teresa Halbach's body into the burn pit, then it could have been checked for fingerprints, but it never was because nobody asked them to. The same with the Rambler hood and the rake and the shovel. If they were, according to the theory, using the rake and the shovel to move around the body parts in the burn pit, then That too could have been tested, but no one asked them to test it. The state indicated in opening statements that this was an investigation of historic proportions in the state of Wisconsin, from number of individuals involved to the cost of the investigation, the resources that were used. Yet they chose not to test anything that didn't fit into their theory of what they believe occurred. What we don't see up to this point and have not heard is anything scientific that matches Brendan Dassey, that places Brendan Dassey at Stephen Avery's at the date and time that Teresa Halbach is killed. No DNA, no fingerprints. If Brendan Dassey is to be believed and the statements he gave to the officer, then every detail in the statements must be corroborated, not picking and choosing the ones that fit your theory. The state has picked and chosen those details and presented them to you that fit their theory, but there are a number of uncorroborated details and inconsistencies that they choose to ignore. Brendan claims they used the creeper to move the body into the fire pit. That is what was presented by Mr. Fallon just previous to my closing argument. Again, as I point out, there is no blood found on either of the two creepers. Never processed. Never asked to process for DNA. They would have tested it if someone had asked them to. An uncorroborated detail. The throat. What's interesting to point out about the state's theory and the state theory is the state indicates they believe, they've argued to you already that Stephen Avery first stabbed Teresa Halbach in the stomach and Brendan Dassey slit her throat. Nick Stockey from the crime lab testified and did indicate that if a person had their throat slit and were alive, it would likely cause what's called blood spatter. This is Stephen Avery's bedroom. This is the bed. This is where the state indicates Teresa Halbach was lying with her arms pinned up against the headboard. The headboard itself, a wooden dresser, a wall, and if you could see further, the carpeting. If, according to Nick Stockey, if she were alive when, according to Brendan Dassey's statement, he slit her throat, there would be blood throughout that bedroom. There'd be blood on the walls, on the headboard, on the posts, on the furnishings, on the carpet. No evidence has been presented to you that anything such as any blood, any splatter, any indication of blood in that area. There's been no testimony and no evidence presented to you by the state. If you recall, I believe John Ertl testified that when they did a luminol test, what Mr. Fallon indicated as well in his closing argument, it came positive right behind the John Deere. When asked, John Ertl indicated that the stain appeared to come and abut up to those boxes. So they did luminol the box, 1.5 feet up on the boxes. Why would they go 1.5 feet up? Well, if there were blood splatter can go up. There might be evidence on the box. There should be evidence on the box. And there wasn't any evidence on the box. Again, the state points out that you must believe Brendan Dassey's statement. If Brendan Dassey's statement is believable, he says to the officers that she was placed into the RAV4 and shot in the RAV4. That's what he initially says to the police. No blood splatter evidence. There's a swipe of blood, the indication of bloody hair. And as was pointed out by the state in their closing argument, passive blood drops which fall towards the ground due to gravity. not splatter. Again, in Brendan Dassey's statement, if he is to be believed, every detail should be corroborated. Those are not corroborated. Neither is the mattress. He tells the officer that there's a blood stain about that big on the bedding, about 6 to 8 inches in diameter. They never found any stain, didn't find any bedding, but they certainly did find, but they certainly didn't find any stain on the mattress. They, in fact, if you recall, asked him, "Did you flip the mattress over?" But there was no stain. Again, if you believe Brendan Dassey's statement, as the state tells you you must believe, then there should be rope fibers, or at least rope. Somewhere on this table of evidence should be some rope. Rope used to tie Teresa Halbach's arms, legs, and hands. As I pointed out to you before, the state commented that Stephen Avery did a good job cleaning up the house. That's why you don't find evidence connecting Brendan, or Stephen for that matter, to any injuries that might have occurred to Teresa Halbach within the house. But if he's been doing such a good job of cleaning up the house, why such a sloppy job leaving blood in the RAV4? His DNA is on the leg iron. His DNA is on the handcuffs. If he wiped those clean, his wouldn't show up. But only his show up, not Teresa's, certainly not Brendan's. Another uncorroborated detail in Brendan's statement. And where is Teresa's hair? Could be in that vacuum. It's possible. I'll grant you that, but the state chose not to look in the vacuum. Could be in the Bissell, I suppose, but they chose not to look at the Bissell either. If there was hair, according to Brendan's statement, Stephen kept it in his dresser. I think he first said he put it on the counter. Upon further questioning by the officers, he changed it and said, "Well, I think it's on the dresser." And not a lock of hair, as Mr. Fallon pointed out. He told the officers, "Cut her hair right off." The state brought in evidence of a cousin who claimed that Brendan told her in December of 2005 that he did see Teresa Halbach. In her statement, she says he said she was pinned in a chair. Contrary to the state's theory, probably why, when Officer Wiegert was questioned about that on the stand, he referred to her being pinned in the bedroom, not pinned in the chair. Kayla said, "Pinned to the chair." When asked, Officer Wiegert said, "Pinned in the bedroom." Why? Because there is no chair that they could find that would match that story. Brendan's drawing of the bedroom. Certainly it doesn't have to be to scale, but I think it should at least match where items are. If the bed were all the way up against the wall, then that drawing should show the same. That's all the way up against the wall. Another uncorroborated detail, the knife. Where's the knife? According to Brendan's statement, if it's to be believed, as the state wants you to believe, it should be in the middle console of that RAV4. That's what he told the police when he first talked to them. He said it was in between the front seats of the RAV4. No knife was found in the RAV4. Later, Brendan changes it and says, "Oh, he cleaned it up and put it back in the kitchen, put it right back in the cupboard or the cabinet." And they got all the knives out. They checked all the knives. They took all the knives down to the crime lab. Nothing with blood on it. Maybe there was DNA, but they chose not to look for the DNA. There is nothing in Brendan's statement, independent of Brendan's statement, that corroborates that there was any sexual intercourse. There's no physical evidence that suggests that. There's no DNA, no evidence of semen or any other bodily fluids in the bedroom, on any other bedding, on the mattress because it wasn't tested, which leads us to the inconsistencies. As I said before, that if you are to believe Brendan's statement, as the state wants you to believe, everything, every detail must be corroborated. If he is so detail-oriented, as Mr. Fallon said, they're such concise detail, such clear detail, then there shouldn't be any uncorroborated detail. And certainly what we've seen is a significant amount of uncorroborated detail. But there shouldn't be any inconsistencies either. But there are plenty of inconsistencies as well. Brendan says in his statement, originally to the officers, I helped carry her to the burn pit, had her by the feet, and he talks to the officers more. He starts to add things. Well, I actually used the creeper, same creeper that was no blood was found. Then he says, well, actually, we placed her body in the back of the RAV4. If this bloodied body was placed in the RAV4, why just a small amount of what appears to be bloody hair? Some passive blood drops on the door. If this bloodied, stabbed, throat slit body was placed in the RAV4, there should be a pool of blood, a stain as big as the back of the cargo area. And there is none. The gunshots. The first person that brings up the idea that she was shot in the head is Officer Wiegert. I believe he even admitted that on the stand. He agreed, yep, I was. I brought it up. Brendan says initially it's 2 shots, but he changes it. It's 2 shots in the head, 1 shot in the stomach, which is okay. Doesn't change the theory of the state's case. They can live with that, but he goes further. It's 3 shots. 1 in the head, 1 in the stomach, 1 in the heart. That's different. Then it's 10, which they want to latch onto because of the casings found in the garage. There are bullet holes in the burn barrel. There are guns throughout this salvage yard, different residences, as the testimony showed. These people have lots of guns. It's not unusual to see shell casings. He first tells the officers that she was shot in the RAV4. That were the case, there would probably be a significant amount of blood in the RAV4, but there isn't. Then he gets back, changes it, and says, well, she was shot on the floor. That's now that matches. That's good. Let's keep that statement. It fits the state's theory, so it must be right. You can ignore all the other inconsistencies. Ignore the fact that he changed his story. Ignore the fact he first said it was in the RAV4. The number of times she was shot, where she was shot. But remember, it was on the floor because that matches the state's theory. The times are inconsistent. He first says he went to Stevens around 4 or 4:30, according to the videotape statement. He also says it was sometime after he got back from school, sometime after 3:45. Later on, he says it was sometime after 6:30. When questioned further, the times are somewhere between 6 and 6:30. In fact, at the very end of that videotape, he says it was actually around 5:30. Now, that might not seem like a big deal, a half hour here or a half hour, but it is a big deal because in order for it to fit into the state's theory, there can't be any times that are close to 5:30 because, as the state pointed out, Mr. Cornelli called sometime around that period of time, 5:30, 5:45, 6. As Mr. Cornelli said, he wasn't sure. It could have been anywhere in that time frame, and they conceded. Absolutely. He called. Probably closer to 5:30, I think, is what Mr. Fallon said, but it probably could have been as 5:45, as Mr. Cornelli said on the stand. But in order for it to fit, the times need to fit the state's theory. You have to ignore all the other inconsistent times. Ignore the 5:30 at the end of the videotape. Ignore the 6 to 6:30. Pick the time that fits the theory. But that's not your role. At the beginning, I mentioned to you what your role is. Actually, I'm sure you all knew your role. Your role is to simply use common sense, make decisions based upon the evidence. Your role is not to be the attorneys. Your role is not to decide who is the victor. This isn't a competition. It's not a basketball game where somebody has to walk away as a winner. If you decide that you have doubt, and it's a reasonable doubt, then you have to acquit. Finally, what I want to talk about, and then I'm going to actually pass on to Attorney Edelstein to finish, and he'll talk about the statements a little further with you and finish up the closing. I want to talk about the sequence of events that occur according to the videotape statement of Brendan Dassey. Initially, he tells the officers that Teresa is stabbed by Stephen Avery, and then she's tied up. He changes that and indicates that Stephen stabs Teresa and then gives the knife to him, and he slits her throat. And then Stephen chokes her and then ties her up. That's what the state has told you in their closing argument is what happened. They've now adopted that theory of what happened. But does that make sense? Someone have their throat slit and then choked. Why choke someone who has just had their throat slit? And if that occurred, there should be a lot of blood in that bedroom. I know we talked about it. I know I spoke just recently about no blood splatter. There's no evidence at all that anyone who was stabbed or had their throat slit in that bedroom on October 31, 2005, or any other time. The state's theory doesn't make sense, and Brendan's statements are just simply non-consistent. At this time, I'm going to pass on to Attorney Edelstein. Thank you. Your Honor, members of the jury, counsel, ladies and gentlemen, on behalf of defense and Brendan Dassey, I want to thank you for your service in this case thus far, but it's a long way from over. We've heard a lot of testimony and a lot of exhibits have been received as evidence. My colleague just went over with you some of the things about the state's case that should result in a finding of not guilty. So much of the inconsistencies, so much of what the state has adopted as their theory that they just got done arguing to you within the last couple of hours is absolutely unsupported by the evidence. When we look at this case, guided by the evidence and the rules of law that the judge gave you, ask yourself at some point, since obviously it's a huge issue, is this statement reliable? Is it believable? Well, things are believable when you can demonstrate that it's accurate. Now, were there some things that he said that turned out to be accurate? Of course, but the state has told you before and insists that this is only because someone there would know, a participant. But that's not necessarily true. These instructions tell you about a reasonable hypothesis, and I'm going to revisit that here in a little bit. Since I guess I'm among the technically challenged here in the group, and you guys have been looking at pictures all week, if it's something critically important, I guess I'll resort to the Elmo. We do have some slides we want you to look at. But let's begin with Brendan. That's where I get to use this. Brendan's 16. At the time, he was in the 10th grade. He has some special education classes. He likes video games. How many times, and think about it, even on that March 1st statement, How many times did the police tell Brendan, start over again, start over again? What did you do? I got home, got off the bus, played video games. What else do we know about Brendan? We have school records. We know from the school records that he consistently does not look adults in the eyes. It would be very easy, and these instructions allow you to use your common sense, and you should use your common sense. Anybody that's ever been around kids and they're feeling bad, and if they did something, they kind of hang their head. They don't want to look at you. And it would be awful easy for the government to get up here and say, all you have to do is look at that. And all you have to do is look at him. And he's covered with guilt, but he's not. Brendan is expressionless. And for the record, and for the benefit of you members of the jury, Exhibit 224. This is from his school. Brendan is expressionless. No facial expression. Seemingly blank stare, possibly indicating daydreaming. This isn't something new. This isn't something that results because, as the state wants you to believe, beyond a reasonable doubt, and that's the standard, beyond, that somehow he's acting funny because of the way he comes across in that video, that he's acting guilty. They want you to surmise things. This isn't about surmising. It's not about guessing. It's about them meeting their obligation under the law to prove each element beyond a reasonable doubt. What else did we learn from the school? On Exhibit 220, this was completed September of 2005. It describes various tests that were given to Brendan. Recalling sentences as a subtest. Age equivalent, 5 years and 8 months. Formulating sentences, 9 years, 9 months. Number repetition. Mr. Fallon, during the cross-examination of Brendan, talked to him about how well he did in math. Number repetition forward. Age equivalent, 5 years, 3 months. Backwards, 6 years, 3 months. His percentile ranks are so low that it's sad. Now, that is not to say that because he may be a pathetic character, and I don't hesitate to say that because nobody can choose their family. You can't choose your parents, you can't choose your uncles, and you can't choose your cousins, and that's sad enough. That's not to say that he negates the horrendous and horrific tragedy that befell the Halbach family. But that is not the issue. The issue is, have they proven each element of every count that they have accused him of? That's where you folks come in. We know from the school records that there are specific learning disabilities, speech or language impairment. Now, why is all this important? We'll get to Dr. Gordon here in a minute, but why is this important about who we're dealing with here? Who everybody here is dealing with? Ultimately, you folks. These officers, when the case began, now I'm not going to sit here and say, well, they're bad guys. No, they're not bad guys. But I sit here and say they did a bad job. Ask yourselves, when you look at this, if they did a bad job and there's not the degree of reliability statement that you believe is required under the law, then you're going to disregard it. When you disregard it, you've got a table full of physical items. They're surely not going to prove anything beyond a reasonable doubt. What did the officers do? You remember Detective O'Neill from Marinette? And I remember him because I'm not trying to pick on him, but we saw a lot of witnesses, and he had the biggest thing hanging out of his pocket that I've ever seen. He's the first one talked with him for over an hour. How did this begin? Remember, he said I had minimal information. Now, I bring this up because as we have suggested and believed to be the case, the police and the prosecution are, to use the phrase of the prosecution earlier in this case, cherry picking. We like this part of his statement, but we're not sure about that, so we're just going to stay away from it. We like this part of his statement, but they were cherry picking. When they testified, for example, they didn't even O'Neill. And he had no reason not to give it up, but he claimed he had minimal information, which really wasn't true. He knew the RAV4 had been found. He knew Brendan was to be interviewed. He was in contact with Skurlinski from DCI, who was in contact with Fassbender from DCI, who was literally at the command post at the Avery property. But even he, when asked, well, did you get argumentative with him? No, it was just kind of a give and take. In his own report, he used the word confronted. Now, I expect at some point you're going to hear an argument because the state gets another opportunity to talk to you and we don't. But you're an argument about, well, this is just good, proper technique. And that might be true if you're dealing with someone of average, normal, typical intelligence, demeanor, and memory. But neither O'Neill, the first one, or Fassbender or Wiegert, the two lead investigators, really knew much, if anything, about this young man before they talked to him. I think Wiegert admitted that. He didn't check the school. He didn't know anything about him. But this is not the typical young man. He might have been on this earth for 16 years at the time, but he didn't act like it, and he didn't think like it. And isn't it incumbent upon the government, when they bring these type of allegations, to be able to satisfy you beyond a reasonable doubt that the evidence that they're asking you to rely upon, in fact, credible and believable, and not tainted because of things that may have been said or done? I asked all these officers about promises, and you folks, you had an opportunity to see the tape. You had an opportunity to listen to it. You've heard portions of it twice, okay? But these are but excerpts from that. Excuse me, if I might, but before we even get to that Mark 3-1 interview, keep in mind that on two separate occasions on the 27th, Brendan was talked to. What did Wiegert say when asked in response to when Brendan Dassey became a suspect? He didn't become a suspect until March 1. You folks can see what's up on the screen. It's a rights waiver. It's the Miranda warning. And didn't Wiegert say there's a big difference between interviews and interrogations? We don't read rights to people. We're just interviewing, trying to get information. He's just a witness. He's just a witness. But on the 27th, when they go down to Two Rivers, lo and behold, Brendan, we're going to read you your rights and you're going to sign this waiver. Why is that? Was he telling you everything there was to tell? It's all these little things that accumulate, that build back some of those bricks of the wall of innocence that surrounds him, which is that presumption of innocence that all of you swore that on your oaths that you would abide by unless and until the state dismantled it by proof beyond a reasonable doubt. Again, one little item, in and of itself, not a big deal, but it's an accumulation of things, and you have to carefully scrutinize everything they bring you before you can decide if they've reached their burden. And if they have not, you must acquit. But here they are on the 27th. They talk to him in Two Rivers. They have him sign that. Mark, can you switch that back? We talked earlier, and there was testimony on cross-examination, particularly about, well, what did you say to him? And this ties in, folks, with what Dr. Gordon had to say. And you're entitled to use your own common sense. Would someone, and this is a question you're going to ask yourselves, would someone admit to something, especially a terrible crime, if it wasn't so? Well, would any one of us? Maybe not. But here, we're not talking about us. We're talking about Brendan. Now, he is not ready for the institution, but he's not going to go to work at NASA either. And he might be lucky to even work down at the local machine shop. We know from the academic testing We know from the testing from Dr. Gordon, he is at the lowest of the low average and then borderline range of intelligence and functioning. But what do the police do? Go back to our little slideshow. There's promises, there's praise, there's negative feedback, lies, and suggestions. Now, they like to give it to other they like to give it other terms. It sounds, I guess, a little softer. In fact, that's how they talk about the soft room. I asked Uyghur, do you think you're a little smarter, maybe a little more sophisticated than Brendan? At first, he really didn't even want to answer that. And then he finally said, well, I should hope so. Well, I should hope so too. You have an unequal balance between the interrogators and Brendan. What are some of the things that are said? We're in your corner. We're on your side, okay? You don't have to worry about things. We'll stand behind you. You're the good guy here. This is critical. These type of statements. Look at the last one. If I don't believe in you, I can't go to bat for you. Anybody that's ever had a child has used somewhat of that same technique. I'm not going to take you to the party. I'm not going to take you to McDonald's to play in the balls. I'm not going to take you to go get ice cream unless you're honest about what happened. In other words, tell me what I want to hear, and then you get what you want. The honest person's the one that's going to get a better deal. Yet, when I asked him, did you promise him anything? No, I wouldn't do that. A better deal? It's not your fault. If someone is repeatedly drilled, that just tell it to us. It's okay. It's not your fault. Nothing's really going to happen to you. Don't you think they might be a little bit more persuaded to adopt what they are suggesting that they adopt? And that occurs repeatedly. We're going to help you through this, all right? He even goes so far as to go over there, patting him on his knee. At one point, I'm sure you folks remember, during the course of that video, Detective Uyghur's over there. He's sitting on the couch in the soft room. Here, draw this picture for me. He tells you. And again, not a big deal in and of itself, but it's an accumulation. Why is it they don't want to tell you everything? Just give it up. It's not that important. But part of it is because they take the position, we're right, nobody else's opinion matters, and you have to accept what we say, hook, line, and sinker. We're the professionals. We know better than you. Well, it's a good thing that not everybody on a jury is a police officer, because the defendant would never have a fair fighting chance. What about praise? Okay, Brendan, you're doing a good job. When they hear what they want, they praise him. It's like patting the puppy and on the head and giving him a treat when trying to get him paper trained, and you get them outside and you go. You're doing a good job. You're doing the right thing. Don't let us down. I think you're doing a real good job up to this point. That makes sense. Now we can believe you. Keep in mind, and I think that's coming up here in a little bit, how many times he was told, we don't believe you. Give us the truth. Be honest with us. I think I asked Uyghur, well, how many times did you say that? He didn't know. I wouldn't expect him to. I wouldn't expect him to sit there and count in the course of a lengthy 3-hour interrogation the number of times he or his partner suggested to Brendan, come on, be honest. Quit lying to us. I wouldn't expect that, but it happened a lot. And it's consistent with this technique. And it wasn't so much at that point that they're interested in getting the truth so much as they want some information. Now, they took that information and ran with it and made it match as best they could. But still, they insist only a person who participated as party to the crime would know these things. And that, folks, is not true. Your cooperation and help with us is going to work in your favor. Now I can start believing you. Here's some of the negative ones. You're making this hard on us and yourself. Don't start lying now. Be honest. You're just hurting yourself. Oops, I'm sorry. I went a little fast. You're just hurting yourself if you lie now. These are just a few of the things that were said to him in these type of techniques. What are some of the lies? They said they didn't lie to him. They called it deceptive practices. It's going to be a lot easier on you down the road if this goes to trial and stuff like that. Why not tell somebody that? It's absolutely untrue. But if they admit to things and you don't verify that what they say is correct, how's it easier on him? You're putting him in a box. They convinced this boy it doesn't really matter. Just tell us. We're your friends. At one point, I think Uyghur, I think it's in our presentation, talks about, I just want to give you a hug. No police officer who's investigating this type of offense, vicious and cruel as it was, can honestly sit there with a straight face and tell you folks, I just want to give this young man a hug when I think he had something to do with this. I'm your friend. Where was she? Come on, we know this already. We know you were back there. And he's talking about the bedroom. We know you were back there. Where's the physical evidence to support that? He wasn't confronted one time. You've all seen this on TV. They're talking to somebody, oh, come on. We know you did it. Somebody says, I didn't. They throw something in front of him and say, well, there's some pictures. Here's some prints. Here's this. Here's that. They didn't know it. This. They kept accusing him of it without one piece of evidence to back it up. And eventually he adopts some of it. Of course, they're going to tell you, well, that's because he finally broke down and told the truth. However, when they make that statement, I challenge you folks to discern for yourselves how much of what he said is true and try to answer that question by what they brought you. Even his own cousin, who they brought up on the stand, it doesn't match. She's pinned up in a chair. That's ridiculous. They never even followed up on that. How is this for a lie? How's this for a lie? Truthfully, I don't think Stephen intended to kill her. Brendan, just tell us, because it was probably an accident. You don't even think Brendan intended to do it. What happened to Teresa was horrendous. Stephen Avery preyed upon that girl when he called and said, send me the same girl. We know what dates she'd been there before. She'd been there. Now, that man, young man, he's not dead and he hasn't been through a fire pit, but if you do what the state asks, he might as well be. There's the hug. How about suggestions? This is where they get to the part of saying, well, now you know, in order for us to believe you, all you have to do is say you did some things, because then we'd probably believe you. It's not your fault. He makes you do it. It's okay. He was telling you to do it. What does Stephen make you do? You went back into that room. Some of these are doubles. We'd be here all day if we listed every category, lies, suggestions, promises. The point simply is, this went over and over and over again. Was his will overcome? Did he say these things because he'd had enough? We know he's highly suggestible. You were there when she died. You helped tie her up, though, didn't you? What he made you do. We know he made you do something else. I think he probably told you. You went over to his house. When the times didn't match, but they wanted it to match their theory, they continually, repeatedly told him that his times were wrong. Yet there's nothing whatsoever to suggest that the Cornelli information is wrong. They're saying that he went over there twice. Now, ask yourself this, folks. Would this young man, even Brendan Dassey, with the limitations he has, and like I said, he's not ready for the institution, but would this young man walk in, who's been described not only by the school personnel as quiet, reserved, respectful, tested out that way with the counselors, the teachers, and other professionals who examined him. Is he just gonna walk away from that trailer like they want you to believe? What was his brother's testimony? I got off the bus. I saw Steve and Avery walking over to that burn barrel, the same burn barrel where Teresa's property was found. What time was that? That was when they were walking home. His own brother said that. Their witness. How many times did he shoot her? Now, Mr. Fallon stood here and told you not less than twice that Brendan Dassey never pulled the trigger. He told you that. That's their theory. They believe that. However, examine the statement. When Wiegert and Fassbender were asking him questions, again, without really having much contact with him, without knowing his cognitive limitations, without knowing how his ability to receive and process information and language, whether it was a good talent that he had, a poor skill, they asked him things like, how many times did you shoot her? Don't they even say they don't even say who they're talking about. And it's in there. If it would say, how many times did Steve do it? How many times did you do it? And they're going to talk about resistance, how he resisted that. But the truth of the matter is, a couple of times when they weren't specific about who they're talking about, he gives an answer, such as a number, and it changes, bounces back and forth. He was confused, he was scared. And let's just briefly touch upon that. Ask yourselves, how probing were they when he told them, I seen it? And he said, he's seen me see it. So he told me not to say something or else it will. He threatened me a little bit. He made it clear to them early on, and they had no reason to doubt it. They just didn't like the answers. They didn't like what he said. But they never explored the potential truth and alternative that this young man walked over there and did see something in a fire, and that something was Teresa Halbach. They go through this scenario and they start. Once he tells them, I seen it, and Steve knew it, and he said, don't say anything, that's when it becomes, you saw this, you saw that. They admitted, and Wiegert testified to it, you saw it on the video. They brought up specific facts, again, that they claim only somebody involved would know, which at some point he adopted. But his adoption doesn't make it true. You all heard the phrase, you can't believe everything you read in the newspaper. Well, you can't necessarily believe everything Brendan Dassey says on a video because there's no independent verification from a source, from any source. You know, you shot her too. Now, how dare the state of Wisconsin come into the courtroom in this state, that statement having been given to a cognitively limited young man, flat out accusing him of picking up that gun and shooting this poor girl. And they didn't do it just once. We know you shot her too. Where? Where's the evidence to support that? He's making it up on the fly. Sounds good to us. Let's see if he accepts it or rejects it. Why would you even do it when you combine that with the types of promises, offers of leniency, telling him it's okay, he didn't do anything wrong, somebody else made him do it, especially when you're dealing with someone like Brendan Dassey? Why? And yet, had the audacity to come in here today and say, we know he didn't do it. Steve Avery shot her, but he helped. He was there. This isn't guilt by association. This isn't guilt by what family you belong to. It's guilt by proof beyond a reasonable doubt. And if they don't climb that ladder, you don't give it to them. What did he do under the hood? They're the first ones that brought this up. You saw the hands and the forehead. Now, I can sit up here all day long and talk about these techniques, these statements, whether it's believable or not. Obviously, we believe it is not. It is not reliable because it is not true that only a person who participated would know these things. How many times during the discussion. On the first day, did they say, "Come on, Brendan, we know you and Stephen talked about it. Mr. Fallon just got up here and told you." And then they went from that bedroom into that front room and had a little chat. That's how he characterized it. A little chat about what they're going to do, how they're going to get rid of Teresa. It's more likely that little chat happened when he walked over there expecting a Halloween bonfire and went around with the little cart and picked up all the stuff, and eventually they start throwing stuff in there. And he probably did see something. Pretty traumatic. Is that reason enough for a young man to be despondent, to be sad? Is that a reasonable hypothesis? This is straight from the instruction. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. That's a very reasonable hypothesis. When he went over there, and I'm sure every one of you is sitting here right now and saying, "Where's this lawyer coming up with this?" Brendan was up on the stand, and he says he got it from a book. And he said, "I don't know," countless times. But he did tell the police. He did tell the police he saw things. Steve threatened him. He told him to keep his mouth shut. Is this a young man whose memory skills, and this isn't just based upon what people like to characterize as the hired gun, it's not just based on Dr. Gordon. The school has no reason to tell you anything that's not so. We know he has these difficulties. It's easy for the state to say, well, the school said he's not suggestible. The school never tested him for that. They didn't test him. They had no reason to test him. Let's look at Dr. Gordon. You remember him. And he's the gentleman going down to St. Louis University. He's been in practice for quite some time. In fact, we had quite the array of specialists and experts in this trial. But that in and of itself, no matter how much the instructions tell you, it doesn't matter how many witnesses. It's not a balance like that. They had more, so they win. That's not how it works. It's not a question of qualifications. Well, they had a lot more experts. But here's Dr. Gordon. He administered these tests. He's shy, socially avoidant, and he has cognitive limitations, borderline to low average intelligence. In fact, he came in and said the two different IQ tests that he provided, which are done as a check against one another, were actually a little bit higher than what the school had. His bottom line conclusion? Very vulnerable to suggestion. You recall when Dr. Gordon was testifying, he gave you this information about some of these tests, various tests that he administered. I don't think there's much dispute about the IQ. That's fairly obvious, even in the video. And if it wasn't obvious in there, folks, if you believe that that poor boy was acting up there, then we should all chip in and buy him an Academy Award. He doesn't have that kind of skill. You saw him. But look where he falls on the 16 PF, on the lowest end, well below average. He's not independent. He's not socially bold. He's not dominant. So when Mr. Fallon suggests he had all these choices, did he really? When he walked over there and saw what he saw, what choice did he have? What choice did he have? Don't hold it against him because he said things like, well, I don't like the police like the rest of my family. He can't pick his parents. He can't pick his uncle. But look at the results on that. That's not someone who's in a position to turn around and either walk away. He probably had no clue what to do. None. Ask yourself, on this Good Johnson scale. Now, they brought Dr. Armentrout in, who said, I've been around forever. I know what I'm doing, and I've never heard of this thing other than what I've looked up on the internet. And I know the guy's from Iceland. Now he's in England. And I really think it's stupid when he asks somebody about being on holiday. Maybe so, but that's only one question. There wasn't anything else he talked about. but Gordon administered the test. It's a recognized, acceptable test. So many years ago, when the prosecution came in and said to judge after judge after judge, we want to use this scientific evidence called DNA. It met with a lot of skepticism, but has become accepted and reliable. This is no different than any other measurement tool. He was qualified to give it, and those are Brendan's results. You heard the testimony about the shift and the yield, and it wasn't just from Gordon. And what does that really mean? Basically, you give somebody a lot of feedback that's negative. He didn't like your answer. Are they going to change it? Yes. And this is a one-on-one. This is not some kind of group dynamic test. This is one-on-one. He's faced 2-on-1 with very skilled, experienced officers who, between the two of them, have got probably about 3 times as much experience just in their law enforcement career as many years as that boy's been alive. And when asked, did Wiegert say in response to the question, well, isn't it true that when you gave him negative feedback that he changed his answer for you? Yes. Isn't it true that when you provided or suggested an answer to him, he changed his answer? Yes, that's true. Like I said before, folks, I'm not sitting here telling you that they're bad guys. They're not bad guys. But this is how they're trained to do this. But you don't apply the same techniques on every single person. That is not cookie cutter. This is not cookie cutter justice. One size does not fit all. And it is incumbent upon them when they bring you what they characterize as a confession to convince you that it is reliable enough that you can hang your hat on it. And in this case, you simply can't. Was it an error? Certainly. It could have been done better. I think they would have even acknowledged that. But that's what we have, and that's what we have to deal with. They might get up and argue, well, gee, you heard this testimony about his ability to resist things, which is not very strong, but he resisted the shooting. What about the phone call to his mom? You guys heard that. Who does all the talking? Barb does all the talking. You could have been the hero. Yeah, that's more of a response. It's not an affirmation in that phone call. And again, trust your collective memory, folks, if it's been different than mine. I know you guys have your little pads the court gave you with all those notes of the testimony. That's mine. I'm going to sit here and go through it. Not right now, but I've looked at it every day during the course of it. But if you remember it different, trust your memory. Did his mom ever say, did you kill that girl? Did Brendan ever say, oh, you bet? No, that's not what happened. It was something like, did you do those things? And what was his answer? Some of it. Some of what? Some of standing around the fire? Some of picking things up with the golf cart? What does that mean to him? It's not that clear. It's not clear beyond a reasonable doubt. Never, ever take anything out of context. You have to look at everything. If all it was a matter of simply saying yes or no, we'd have left here days ago. In fact, I made a point of demonstrating with Detective Wiegert just how easily Brendan would go along. How many times did Wiegert say things like, Brendan, say yes or no? And Brendan would go, yes. I remember one other time, same interview, Brendan, say yes or no? No. He's doing what he's told. His limitations are such that he can't go from the question up to the top of the page. Halfway down, when they're coming back to it, when they have interposed in between their promises, assurances, lies, and then they come back and say, aren't we right? He might say, yeah. Tattoo's a perfect example of that. They claimed, and they presented to you, that they brought that up as an example of how he could resist suggestion. Wrong. They're just wrong. All he did say in response to Wiegert, when Wiegert insisted that Teresa had a tattoo, was when Because I think the question was, do you disagree with that? And he said, no, but I don't know where it is. That makes no sense. They want you to believe that the response means one thing when, in fact, it means something totally different. The reliability of that video, of that statement, is such, combined with the expert testimony that's been presented in this case, which has not been refuted. Armentrout has never even heard of this. And the only thing we could do is say, well, I don't see any notes on the score sheet here, so I don't have a lot of faith in this. These are some things we already talked about. Gordon's assessment's consistent with the school. He has many deficits, and Armentrout doesn't know much about this test. Mr. Armentrout went so far as to say, I saw the word suggestible one time when I was checking the internet. And again, he offers his opinion about why Gordon shouldn't be believable. But there's no basis for that. Ladies and gentlemen, on behalf of Brendan Dassey, Mr. Fremgen, myself, I want to thank you for your service in this case. It's been a long period of time. But this is so important that you abide by your oaths that you took when we first met you, when this case first began, and to deliver a true verdict based only on the law and only on this evidence. And when you review it all and you listen to one another and you take the time necessary to consider it and use your common sense, don't just rubber stamp the version they provide you, keeping in mind it is their burden, and it's an awesome burden that they have not removed those bricks of protection, that presumption of innocence that surrounds him. Don't convict him because this was a horrible thing. Don't convict him because he couldn't pick his parents. Don't convict him because he simply doesn't know, and he's honest about it. If he doesn't know, and you believe him, and you judge him like you would anyone else under the instruction of credibility, you should, and we hope that you will, return verdicts of not guilty on all counts. Thank you very much.
Would you like me to go, or do you want to take a break?
Let's take 15 minutes.
All right.
All right, we were back at 10 of the hour. Mr. Fallon.
Thank you. Let me begin by making 2 points crystal clear. We are here, and we're here for one reason. There's no issue, there's no doubt. We're here because the defendant has a constitutional right to have us prove him guilty. That's why we're here. That's what we've done. There's no mystery here. There's no issue here. Point number 2. For all that stuff that counsel showed you on the screen, and for all this testimony, I think there's one thing that's inescapably clear about the defendant. While not the sharpest knife in the drawer, he's clearly low average intelligent. He's a mainstream student. He's got 2 special classes. All right, and I think counsel's probably misspoke, but let me clarify something. He wasn't reading as a 5-year-old. He was reading as a 5th grader. Let's just keep that clear, because he has some difficulties in reading, which certainly makes one wonder as to what books he was reading, by the way. But we'll get to that. First point I want to make is this point because I think it's significant and it feeds into the whole question of suggestibility, or should I say the absence thereof. And those are the statements to Kayla Avery. Now, let's think about that. She's telling us in a statement in which she denied on the stand she had a conversation with the defendant in December about body parts and people being pinned up. And while she thought he said chair, we got pinned up, we got body parts in a fire, we got blood coming out of the concrete floors, right? Now, think about that. She was so upset, so moved by that revelation, she went on to her counselors in early January. Now, if you were 16 years old, if you were in a situation like this, what would be the most disturbing images for the experiences if you really experienced it? It would be those images of a woman pinned up, of body parts in a fire, of blood coming out of a concrete floor. Those are the things that you would stick out in your memory. And I tell you that because you know what? That's why he confessed, because he couldn't live with it. And it started to eke out in his discussion little by little, peeling the onion little by little to his first cousin first, his peer, followed by all the trauma of that winter, the loss of weight, the tearful sessions, sitting at a birthday party and he's in tears because he's by himself. Why? It's not because he lost a girlfriend. It's because he couldn't live with it. And when we get to the discussions of the interrogation, that's the angle the officers took. That's why he confessed. All right. Theme 2, the absence of DNA, the absence of evidence. Well, it's been a while since I had my human anatomy class, but there are certainly questions about where there isn't just coddles of blood all over that room if there was someone's throat cut. But think now. Think about that description the defendant gave you on the videotape. As I said, across the front of the throat. And I believe my recollection is it was above the Adam's apple. Now, the last time I looked, the carotid artery or the jugular vein, which seemed to be in common parlance, are on the sides of the neck. You're not going to have a whole lot of blood spurting around with cut across here, which, by the way, is a correct testimony of Mr. Stockey from the crime lab, the blood spatter expert. Sure, if you cut somebody on their carotid artery, you're going to have blood spurting. If you cut them across here, there isn't going to be a lot of blood. And that's also consistent with, and also makes the defendant's version credible, because he wasn't entirely sure that he wanted to cut all the way through. As he said, he put his fingers up like that and showed you a small cut. Not a laceration, not a severed artery or vein. There's more evidence in that room because the bedding is burned. He tells us that. The defendant is cleaning up. What's he going to do? Not put bedding back on the bed. He's got to sleep. He doesn't know when and if the police are going to come. He's cleaning the room. He's going to put fresh bedding on there. And remember, he's got 4 days to clean up. Tuesday, Wednesday, Thursday, Friday. That's 4 days. The police show up on Saturday. 4 days to clean that house. 4 days to clean. He already knows about bleach. We got bleach all over that garage. You think it takes 2 seconds to wipe down some handcuffs? Absolutely not. Counsel was saying, well, why didn't they wash the handcuffs? Well, there's a difference between handcuffs sitting around for 4 days in the exclusive possession of Stephen Avery and a bullet that neither one of these guys knew existed, being found 4 months later in the garage that she was able to obtain a profile from. And probably most importantly, let's talk about this. Just because there's no DNA profile, just because there's no fingerprints of the defendant present, doesn't mean he wasn't there. Doesn't mean he didn't do it. As Ms. Culhane told you, very easy, it's still fragile, DNA degrades. DNA gets cleaned up. Mr. Riddle told you fingerprints entirely dependent upon the nature of the substance and to atmospheric conditions, weather conditions. After all, what did he tell you? They're 98% water. That's why there's no prints on a car hood sitting outside for 4 days, which, by the way, last time I looked, the car hood isn't exactly your brand new car off the showroom, such as it's going to hold print. I'm surprised the defense didn't try to sell you a bill of goods and say, geez, why didn't they just test the car seat for prints? I'm not going to even address the hairs in a vacuum cleaner. That's ridiculous. The best example for the absence of evidence, even though we know someone was there, is Stephen Avery. He's driving the vehicle. He drives it down there, right? He's opening the doors. He's driving the vehicle down there. His prints aren't on there either, are they? They're not. We know that he's there because his blood was there, because he left the blood in there. Counsel will say, well, didn't he clean that up? Because he didn't think he had to, because he was going to crush that car. Because he was going to crush that car. That's what he was going to do with that car. Don't have to worry about cleaning up that car. Another day or two, that car would have been gone. And finally, why is there no defendant DNA there? Well, the last time I looked, I don't think anyone said Brendan Dassey was actively bleeding. There's no cut on him such as that blood would be found anywhere. All right, let's talk about interrogation. First of all, let's keep in mind this is a gruesome rape murder. This isn't your average retail theft, your average burglary, your average anything. The interrogation conducted by these officers is nothing short of exemplary, skilled, talented, pointed, and directed, as I suggested, to appeal to his sense of guilt. They heard, they knew, they had that feeling. As counsel tells you, they've got 3 times the experience that he has in years on the earth. They appeal to that sense of guilt. They had a hunch that he wasn't going to be able to live with it. And they were right. People who are innocent don't confess in the detail provided to the extent this defendant provided. They don't do that. This isn't your walk in off the street, I killed John Benet Ramsey. We're about as far away from that idea. And I'm not quite sure where Dr. Gordon's coming from, but I'm sure glad he's going to Missouri. People who are innocent don't confess. The defendant confessed because he was guilty, because he did it. An innocent person is going to deny the suggestion. They're not going to admit to this, not to the degree that the defendant did. Now, let's keep in mind one other thing. In mind. I'll listen to that argument. It makes my blood boil, because those officers treated the defendant a heck of a lot better than he treated Teresa Halbach. Now let's clear up this corroboration issue. The defense, in their opening comments on the argument, suggested to you that we need to corroborate everything in his statement. That's not true. That's not the law. We need, as Mr. Edelstein corrected his colleague, we need only to prove beyond a reasonable doubt that the elements of those offenses, the murder, the rape, and the mutilation, we don't have to corroborate. We don't have to prove every single solitary thing. We'd be here for the next 6 months. We're required to prove to you beyond a reasonable doubt the elements of the offense, the facts that make him guilty. So let's look at some, what I would characterize as irrefutable corroboration. And it comes in facts that were either known only to the killers or the facts that weren't discovered until after the defendant provided them. How about that Teresa was shot in the garage? Sure, the officer said, well, who shot her? We could ask. He got tired. He got impatient. He says, well, who shot her? He said, he did. Who's he? Stephen. Where? In the garage. Where did that come from? With what? A .22 caliber. More than once in the head, and in the left side of the head. And that the clothes were burned. That was not discussed. The officers had found some rivets. That's true. And they knew there was at least one gunshot to the left side of the head from Dr. Eisenberg's initial report. But who else would know that? You don't know that unless you're there. That wasn't suggested, because if it was, you can bet counsel would have shown that little tape to you. Even though he doesn't want to take anything out of context, I didn't see any of the answers or any of the setup to any of those questions that he flashed on the screen so interestingly. How about some facts discovered after he talked? That was more than one shot in the head. You recall, it was later on, as Detective Wiegert told you, that they learned that there was at least another gunshot in the head. They didn't know more than that on March 1. How about the location of the bed? Counsel would have you believe that because the defendant's version of the placement of all the furniture is somewhat different than Jody Stokowski's, that he shouldn't be believed. Again, core details versus peripheral. What's important? What's not? The location of the bed is the orientation fact, or is the critical fact. In other words, you can look down that hallway and see that bed, and that's the point. The other critical fact is we know because when the search warrant was executed, the bed wasn't there. The bed was underneath the gun rack, also signifying that the room was cleaned and moved in an effort to thwart the investigation efforts, in an effort to cover up this crime. In fact, as you heard Detective Wiegert tell you, geez, we didn't think that made any sense. We just thought that was just one of those things that we couldn't explain until they went and they talked to Jody Stokowski. And they said, well, by the way, before you traded off to jail, where was that bed? She said, under the window, on the wall by the door. All right. And after he talked, they executed a search warrant. And what did they find? They found the bullets. Nobody knew those bullets were there. Nobody knew for sure until he said they were shot. She was shot in the garage. And they go back, well, let's look for the bullets. And lo and behold, they found a bullet with Teresa Halbach's DNA. What else did they do? They went back and they said, counsel will say, we'll make a big deal out how they suggested to him that he went under a hood. Well, let's take their argument at face value. My response is, so what? They went and they swabbed the hood, and geez, guess what? Stephen Avery's DNA is on that hood. Let's talk about successful resistance. There were many examples. Think back. Many times the officers, well, what about the wires hanging in the garage? Did you guys use those? Did you do anything? Did you string her up? Did you use those? Nope. He never bought into that. He never adopted that. He said, no, there was never any blood on me from Teresa. Nope. He resisted knowing anything about what happened to the hair that he cut off her head. They tried to get him to say, well, you've got it. Stephen's got it. Where is it? He didn't know. He didn't adopt that suggestion. He didn't adopt the suggestion when the officers pressed him, well, you were the one. How could you see this stuff in a burn barrel? How did you know that was a cell phone and all that stuff if it's in a bag? How could you have known that? You were the one who put it in there, weren't you? He didn't adopt that suggestion. And when he finally admitted to the rape, they went back at him again and they say, well, you saw Stephen rape her too, didn't you? You were there when he did it, right? And he said, nope. He didn't adopt that. But you know what the most important suggestion resisted here? And that's the suggestion that he shot Teresa Halbach. And you all know why he was asked that. Because finally he did cough up the fact that he held the knife and he cut her throat. So the next logical question is, well, you also shot her too, right? And they went at him several times during that, and not once the royal you and the individual you were cleaned up for him so that he understood. He never said or that he touched or shot that gun. He resisted the suggestion. And while counsel has him 1 foot away from the institution, his presentation on the witness stand is far from that. I don't know about you, but he seemed to resist my suggestion pretty well on cross-examination. At least to the extent, well, you saw body parts in the fire, didn't you? No, I didn't. He resisted several of my suggestions, but most of them he just said, I don't know. We'll come back to that in a moment. Well, the defense called Dr. Gordon. I don't know what more we can say about Dr. Gordon, but I took a couple of things if you want to believe them at all. Here's a guy who's using this test, which is normed, developed on Europeans, a test he just recently got himself. He said after a year of trying, so it's not like he's used to this test. He's used this test a lot. A test about Anna Thompson on holiday in the south of Spain, who who loses 50 pounds of traveler's checks. Well, what is a kid from Wisconsin going to relate to that? Counsel says, well, it's only one sentence. Sure, it's only one sentence. Then Dr. Gordon uses the Wechsler abbreviated scale of intelligence. And as we heard, the Wechsler scale of intelligence has 11 scales, but you can give somebody the short version, the Reader's Digest version, because it's got 4 scales on there. And to give it to you the idea of how he would probably test out if you took the time to run the whole test, right? Well, our esteemed Dr. Gordon only bothered to run 2 scales out of the 4 on the abbreviated test. So he's abbreviating the abbreviation. No matter. And then he has the nerve to try and mislead you by using the scoring criteria for the DSM-4, the Diagnostic and Statistical Manual for Mental Disease and Disorders, and apply it to the Wechsler test, when the Wechsler has its own scoring criteria, all in an effort to make the defendant to be less intelligent than he is. I could go on about Dr. Gordon, but the one thing Dr. Armentrout said really made sense. 2 words. So what? As Gordon said on cross-examination, he's suggestible to telling a confession. Could be telling the truth. Could be telling, I can't say, I don't know. So what? All right, we come now to the defendant. Counsel talked about the presumption of innocence and reasonable doubt. The defendant takes the stand, says, I didn't do it. I made it all up. Believe me. And when I asked why, repeatedly asked, why did you do this? Why did you do that? He said, I don't know. He must have said, I don't know 30 times, which, interestingly enough, is about how many times the officers told him to tell the truth during that interview. While a defendant is presumed innocent, he is not presumed believable. He is not presumed credible. When he gets there and he tells you, I don't know, I didn't do it, I made it all up. I want to play for you one brief clip and ask yourself, do people confess to rape, to murder, and mutilation if they didn't do it and then apologize for it? There's your motive, as sad as it is. Just as Teresa's lifeless body was consumed by that fire on Halloween night, the defendant's presumption of innocence has been consumed by the fires of his own desire. He wanted to know what it was like. His presumption of innocence has been destroyed by the fires of his own guilt. There's only one verdict here for each count, and that's a verdict of guilty. And we ask you to bring that verdict. We ask you to bring justice for Teresa. Thank you.
Ladies and gentlemen, I'm going to read to you closing instructions and several others. Now, members of the jury, the duties of counsel and the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind, and as upright citizens to render a just and true verdict. The following forms of verdict will be submitted to you concerning the charges against the defendant, Brendan Dassey. We, the jury, find the defendant, Brendan R. Dassey, guilty of first-degree intentional homicide as party to a crime on October 31st, 2005, contrary to Section 940.011A, 939.50 3A, 939.5 Wisconsin statutes. We, the jury, find the defendant, Brendan R. Dassey, not guilty of first-degree intentional homicide as party to a crime on October 31st, 2005, contrary to Section 940.011A, 50.3A, 939.5 Wisconsin statutes. We, the jury, find the defendant, Brendan R. Dassey, not guilty of first-degree intentional homicide as party to a crime on October 31st, 2005, contrary to Section 940.011A, 939.5 Wisconsin statutes. We, the jury, find the defendant, Brendan R. Dassey, not guilty of first-degree intentional homicide as party to a crime on October 31st, 2005, contrary to Section 940.011A, 939.5 Wisconsin statutes. We, the jury, find defendant Brendan R. Dassey guilty of mutilating a corpse as party to a crime on October 31st, 2005, contrary to Section 940.111, 93950 3F, 939.5 Wisconsin statutes. We, the jury, find the defendant Brendan R. Dassey not guilty of mutilating a corpse as party to a crime on October 31st, 2005, contrary to Sections 940.111, 939.503F, 939.05 Wisconsin statutes. We, the jury, find the defendant Brendan R. Dassey guilty of second-degree sexual assault as party to a crime on October 31st, 2005, contrary to Sections 940.225.2A, 939.503C, 939.5 Wisconsin statutes. We, the jury, find the defendant Brendan R. Dassey not guilty of second-degree sexual assault as party to a crime on October 31st, 2005, contrary to Sections 940.225.2A, 939.503C, 939.5 Wisconsin statutes. We, the jury, find the defendant Brendan R. Dassey guilty of first-degree reckless homicide as party to a crime, a lesser included offense on October 31st, 2005, contrary to Sections 940.21 and 939.05 Wisconsin statutes. We, the jury, find the defendant Brendan R. Dassey not guilty of first-degree reckless homicide as party to a crime of lesser included offense on October 31st, 2005, contrary to Sections 940.21 and 939.05 Wisconsin statute. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury can return a verdict which may be illegally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at the verdict. When you retire to the jury room, select one of your jury members to preside over your deliberations. That person's vote is entitled to no greater weight than the vote of any other juror. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. Before we swear the jury officer, I'm going to ask the clerk to draw 3 names from the tumbler. The first 2 of those names will be jurors who are discharged. The third will be the juror who will remain sequestered. As to the discharged jurors, I'm going to order the following: that you are not to discuss the matter with the media or anyone else until the verdict has been received by this court. Once the verdict is received, you may, but are under no obligation to discuss your participation in the case with the media or anyone you choose to discuss it with. Madam Clerk.
Judge, one thing, are we going to keep the name?
I thank you for reminding me. I'm going to ask you at this point that any audio be muted so that any name is not a matter of public broadcast. Thank you.
The first one is number 11, Renee Schmidt.
All right, remain there just a second. Miss Schmidt.
Second one is number 10, Cynthia Edge.
All right, Miss Edge and Miss Schmidt, stay there for just a moment, but you will be the jurors who are discharged. Draw the third name, please.
Third one is number 1, Thomas Oakes.
All right. The 3 of you would exit the jury box, please, and join the officers here. He will escort you out. All right. Would you swear to the jury officer, please? Madam Bailiff, here are the original verdict form and 12 forms for the jurors to review. Be seated. The court is going to adjourn during the deliberations. Of course, we may have to return in the event questions are asked. The court will provide an hour's notice to the people who request it. After the return of the verdict, before the verdict is announced, which may or may not be tonight, all right, we are adjourned. This is State of Wisconsin versus Brendan Dassey, 06 CF88, appearances, please.
The state continues in its appearance by Special Prosecutors Ken Kratz, Norm Gahn, and Tom Fallon.
Attorney Mark Fremgen appears with Attorney Ray Edelstein. Defendant appears in person.
We are here to receive the verdicts from the jury. Before the court receives the reads from the verdicts, I want to remind all those present that this is a court of law. The court requires that the emotional nature of this case and its importance to all parties involved, however vocal outbursts or displays of emotion, will not be tolerated. Any violation will result in removal from the courtroom. Ladies and gentlemen, have you chosen a foreperson?
Yes.
I ask that a foreperson hand to the jury bailiff these verdicts. As to count one, we, the jury, find the defendant, Brendan R. Dassey, guilty of first-degree intentional homicide as party to a crime on October 31st, 2005, contrary to sections 940.01, 1A, 939.50, 3A, 939.05 Wisconsin statutes, dated this 25th day of April 2007 and signed by the foreperson. As to count two, we, the jury, find the defendant, Brendan R. Dassey, guilty of mutilating a corpse as party to a crime on October 31st, 2005, contrary to sections 940.111, 939.50, 3F, 939.05 Wisconsin statutes, dated this 25th day of April 2007, and signed by the foreperson of the jury. As to count three, we, the jury, find the defendant, Brendan R. Dassey, guilty of second-degree sexual assault as party to a crime on October 31st, 2005, contrary to sections 940.225, 2A, 939.50, 3C, 939.05 Wisconsin statutes, dated this 25th day of April 2007. I'm going to poll the jury at this juncture. I ask that any audio that is currently being run in the courtroom be muted or turned off. I'm going to start in chair number 2 and ask Mr. Hughes, were these your verdicts as read by the court, and are these still your verdicts in this case?
Yes.
Ms. Tedder, were these your verdicts as read by the court, and are they still your verdicts in this case?
Yes.
Ms. Shee, were these your verdicts as read by the court, and are they now still your verdicts in this case?
Yes.
Mr. Heinzel, were these your verdicts as read by the court, and are they still now your verdicts in this case?
Yes.
Ms. Foss, were these your verdicts as read by the court, and are they now still your verdicts in this case?
Yes.
I'll go to the front row. Mr. Covington, were these your verdicts as read by the court, and are they still now your verdicts in this case?
Yes.
Miss Running, were these your verdicts as read by the court, and are they now still your verdicts in this case?
Yeah.
Miss Orff, were these your verdicts as read by the court, and are they still your verdicts in this case?
Yeah.
Miss McGuire, were these your verdicts as read by the court, and are they still now your verdicts in this case?
Yep.
Miss Lowry, were these your verdicts read by the court, and are they still now your verdicts in this case?
Uh-huh.
I'm sorry.
Yeah.
All right. Miss Shippey, were these your verdicts as read by the court, and are they still now your verdicts in this case?
Yes.
The polling has been completed. Members of a jury, on behalf of Manitowoc County, I would like to express my sincerest gratitude and appreciation for your service in this case. I recognize, particularly in this case, that personal sacrifice in terms of time and restrictions on your normal activities has been required by this trial. That sacrifice is a necessary part of the price we pay for the judicial system every citizen enjoys. You, as jurors, act as a collective conscience of the community in making these decisions. Again, I thank you. Before discharging you, I have one final instruction. Now that your service in this case is completed, some of you may have questions about the confidentiality of the proceedings. Many jurors ask if they are at liberty to discuss the case with anyone after receiving the verdicts because your role in the case is over. You are free to discuss it with any person you choose. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than the court. If you decide to discuss the case with anyone, I would suggest that you treat any discussion with a degree of solemnity, such as whatever you say you would be willing to say in the presence of your fellow jurors or under oath here in the open court in the presence of the parties. Also, always keep in mind if you do decide to discuss the case that your fellow jurors fully and freely stated their opinions with the understanding they were being expressed in confidence. Please respect the privacy of the views of your fellow jurors. If any member or members of the jury wish to discuss the case this evening with the representatives of the media, arrangements can be made to permit you to do so before you leave. If you wish to do so, let the bailiff know that is what you desire. Should anyone, whether from the media or otherwise, persist in attempting to question you over your objection, you should contact the court. Finally, should any of you have any question for the court before leaving this evening, please let the bailiff know before you leave the jury room. Again, thank you. You are now excused and discharged. Mr. Kratz, I see the microphone in front of you. Do you have a motion?
I do, Judge. I'd ask that the court enter judgment on the verdicts.
The court will, based on these verdicts, enter judgment of guilty as reflected in the verdicts of the jury. Are we prepared at this point to set a sentencing date?
Oh, we can certainly set the date, Judge. There are two requests that I would make. First, I would ask the court order a pre-sentence investigative report. I'm sure that will be done as a matter of course. Secondly, given the nature of the convictions, and although the bond and bail that has been set in this case is rather high, given the mandatory sentence that is necessary and imperative in this case, I would ask that the court revoke bail at this time.
Defense wish to be heard?
No, Judge.
All right. The court will, for the reasons stated by the prosecutor, revoke bail in this case. Court will order that a present tense investigation be completed in July 9, 2007. I would like to set a sentencing for July 17, 2007. And this assumes that your calendars are open that day?
Judge, I have a 2-day trial, Monday and Tuesday of that week.
Your calendar's not open?
It is not open.
All right.
Perhaps the week before that, Judge. I know at the end of July I have a week-long arson trial. But if the court could set it, perhaps maybe move up the PSI and set it for the second week of July.
The difficulty is in moving up the PSI.
I understand.
I'm sort of cutting it close on that one in the first instance. I could certainly set it either later on July towards the absolute end or the beginning of August, if that.
The first couple of days of August would be just fine, Judge.
How about Monday, August 6th?
That's fine.
9 o'clock a.m.?
Yes, that's fine.
August 6th at 9?
Yeah.
That will work out fine. Thank you, Judge.
Do you still want the PSI to be done in July?
Actually, we can move the PSI to the
16th, maybe? That's a week later.
Yeah, the 16th is a Saturday, so well, that's June, excuse me. Yeah, the 16th is a Monday. That's fine. PSI will be due then on the 16th.
Do you want an order drafted on the bail revocation?
State will draft order on the bail modification.
I will, Judge.
Sentence in 9, August 6. Anything more to come before the court this evening?
Not today, Judge. Thank you.
No, Judge.
Good evening then.